We ready?
That was my real thesis with ourselves vulnerable.
Call the meeting to order. This is the July 16, 2014 meeting of the Town Planning and Zoning Commission for the Town of Fairfield. This is a continued public hearing for 92-140 Bronson Road, zoning compliance and coastal site plan application of Garden Homes Management pertaining to a proposed 95-unit residential development pursuant to Section 830G of the Connecticut General Statutes. We last left off last night with Attorney Green hopefully finishing his proposal when his presentation when we begin. Then we will have any additional public comments, following which the applicant will present their rebuttal. The applicant gets the last word. When the applicant is finished with their rebuttal, the hearing will be closed. Without further ado, Attorney Green.
Yeah, well, I'm going to have to.
Thank you, Mr. Chairman. Once again, Mr. Chairman, members of the Commission, staff, and the public, my name is Joel Green. I practice law in Bridgeport, the offices of Green and Gross, and it is once again my pleasure to appear before you this evening on behalf of the Lower Bronson Neighborhood Alliance. Pursuant to the Chairman's request, I did submit a series of documents today before 1 o'clock, and for the most part with a few minor technical errors. And I did provide Mr. Wendt with CDs containing all of the documents for your convenience to the extent that the email is problematical. I know that some of the documents were rather large. I have also provided staff with one copy of the code on traffic because it's a 480-page document. I have not produced a copy of that, but it is once again on the disk. As a housekeeping matter, I do have some just brief matters that I'd just like to cover. I have just an article. I suppose I should preface my remarks tonight by saying that it's my understanding that together, jointly, we are going to work towards completing this hearing, the public hearing this evening. Toward that end, I have significantly streamlined my presentation. I understand that Mr. Fallon has done the same and will be succinct with his presentation. But I make that remark because I will move kind of quickly over some things, and in the spirit of getting this done, I have done that. So,
And we appreciate that very much.
So I'm going to present an OSHA article called Fire Service Features that I think it's a general article that OSHA published, and it deals with many of the issues that we've talked about in terms of building and site design and its impact on fire safety. So I think Mr. Wendt may have printed it, but I have a few copies to hand around if the public is curious. Mr. Blumenthal will circulate some documents to pass around. Similarly, without being redundant and without covering too much ground, I have a memo that was prepared by Jim Wendt dated July 9, 2014, which is a response by TPC staff. And this deals with the applicants offering at the public hearing on July 8th certain AASHTO guidelines. And rather than get deeply into that, our response is very similar to staff, and so I'm going to, on behalf of Lower Bronson Neighborhood Association, adopt the reasoning in Mr. Wendt's memo, and I'm going to provide that to the Commission as well. All right, so at this point, I would like to just address some of the issues on parking, and I have for the commission an excerpt from a report. And this is just a portion of the traffic report that was prepared by KWH Enterprise. It's in the materials that were submitted by the applicant, and for the convenience of the commission, I just want to, I'm going to submit an excerpt, and once again, it's pages 216, pages 217, page 233, and page 234 from the materials submitted by the applicant. And you'll see basically the cover of the report is there, but I really wanted to emphasize the following. First of all, our experts, each of the applicant produced an expert, and we had similarly produced an expert. And the experts both spoke in terms of the ITE criteria. And I suppose that on rebuttal, the applicant will will offer more information or the testimony of their traffic consultant on this ITE issue. And I suppose there's a bona fide dispute between the parties, and the commission may even find that, you know, that the scales are equal, and it's hard to judge between the two on what an appropriate position is just based on ITE. But I note that looking at page 217, the applicant said that, or KWH offered in their summary that the proposed parking ratio of 1.2 spaces per apartment is more than sufficient based on ITE criteria, which we have a dispute on. But then there's a statement that says, and parking surveys conducted at other properties in the region. I then refer the commission to page 233, and there's a section 6 on parking, and it refers to, in paragraph 2 of that lead paragraph, the adequacy of this parking ratio is confirmed by, once again, 1, the ITE parking generation, but then it says 2, parking surveys conducted at 4 properties owned by the applicant in the region. And on the next page is a table 7, and it compares, and it says parking demand at similar developments. Now, first of all, let me say, as a matter of common sense, the 1.2 figure, for all of the reasons that I think I questioned our consultants last evening on, I am very skeptical as a matter of common sense with the 1.2 factor per unit, and that's once again based on the fact that there will be couples occupying these units, and there's no particular mix. And I understand that there may be preferences based on whether it's a studio or a one-bedroom apartment, but there'll be couples. The affordability plan even refers to families occupying this, up to 4 people occupying a unit. There is a community room, and we spoke about that. There are guests who come to visit. There are deliveries. There's home care help. There's a lot of ways in which traffic is generated. And I would suggest that as a matter of common sense, I think the 1.2 is extremely suspect, and I think it's too low. And once again, our zoning regulations require 3 spaces per dwelling unit. But the comparison to other sites was something that struck me when I looked at it and had me scratching my head, because it occurred to me when I first looked at it that it might not be apples to apples. And there are a lot of factors that affect the parking load. And the first thing I would note that underneath the chart, it says in very small letters, it says sources, Traffic Engineering Solutions PC and Frederick P. Clark Associates. I suppose the applicant can explain on rebuttal what that means, but my understanding of it would mean that these were probably based on traffic studies that were done at the time these projects were proposed, perhaps. I don't know. That's not clear to me. I would also note that the parking studies were, at least in 3 instances, conducted more than 5 years ago, and in one instance on Boston Post Road in Darien 2 years ago. So it occurred to me, though, that the efficiency and the need of parking is driven by a lot of factors, and they include the availability of parking in the area. Is there a large public parking lot? Is there street parking? Are there other facilities for parking available that would sort of mitigate the need for on-site housing? Similarly, is there public transportation in the region such that someone might say, you know what, I really don't need a car because I can take the bus, take the train, or indeed, if it's in a more urban setting, I can walk to work. And there's a lot of factors. So I think that in considering the comparables, one really has to drill in a little bit and look at them. So what I did was I asked our intern, Jacob Blumenthal, who's here tonight, to do a study and to prepare an analysis and a comparison of the 4 sites that were presented by the applicant at page 234 of the traffic study. I'd like to call him forward to discuss his methodology and his conclusions. And I have a larger scale version of the drawing that was circulated to you today by email. And I will introduce Mr. Blumenthal, who's an intern in our office, and call him forward, and maybe you can tell the commission about what your charge was and what your methodology was in conducting your study.
Hi, for the record, my name is Jacob Blumenthal. I've been working as a part-time intern at Green & Gross. So my job was pretty simple, and my methodology is not anything too hard to understand. Attorney Green asked me to go and just check out these sites pretty observationally and just see how they compare to the site on Bronson Road. And across the board, it was pretty easy just from looking at these sites. I spent a little bit more time walking around them, getting to know the neighborhood, seeing what was around, but just from looking at the roads they were on, it was pretty apparent that these sites are very different and would have very different parking needs than what would be the case on Bronson Road. So I believe what you have now is a table of just some of my notes that I put together very briefly, again, primarily just from observing and exploring the neighborhoods, and I can go through some of the specifics with you, but these were in much more developed, much more urban neighborhoods across the board, and there were a lot more amenities in the area, different stores and restaurants that would be much easier to get to on foot. They were all on bus lines that would be easy to take, near train stations that would be easy to walk to, and there were also many other alternative places to park, be it either street parking or public lots, or even stores that one could park pretty easily, though technically illegally.
Maybe you could just highlight, based on beginning with driveway parking lot on the 4 projects. I should also just add, for the benefit of the commission, that I had added in an additional site, being the Fairchild site in Fairfield, as a comparable, just to add another site for the commission's consideration. And if you could just go through the various categories, and I know some people don't have copies of this, so if you can just describe what you found with respect to the various projects.
Okay, so my first charge was sort of taking in whether the driveway and parking lot to these buildings would be similar to the site on Bronson Road. As we've gone over many times, the site on Bronson Road would require a long, rather narrow driveway to get to the parking lot. On none of the other sites was this the case. In Sterling Towers and Derby, there was a parking lot with 2 separate entrances, one straight entrance with no exit that you could not exit through, and one that was both an entrance and an exit. There was parking to the sides and behind the building that made a large, spacious parking lot. In the Darien site on 397 Boston Post Road, the residential building had parking to the front and side, and it was accessed by 2 short separate driveways. So again, it was possible to enter and exit through separate driveways, which is different than the Bronson Road site. At 85 Cove Road in Stamford, there was also a driveway with 2 separate entrances, 2 separate driveways, one to enter and one to exit. And then at the Maple Court Apartments, also in Stamford, there was only a lot with 1 entrance. However, this was much closer to the street with a very short entrance to get into. So the parking lot was basically right on the street rather than having a long driveway to drive up.
Okay, on alternative parking options, I think you can probably summarize that. Did you find, what would your general summary be with respect to these 5 properties?
So all 5 properties had options very close to the sites where you could park either as a resident or as a guest very easily, either for a small fee or through a residential pass or with free street parking.
And what about in terms of local amenities with respect to the 5 sites?
All 5 sites, to varying degrees, had local amenities nearby. The Fairchild Road site has them a bit of a walk away, as was the Maple Court Apartments. You had to walk across an intersection. However, for the other sites, they were literally across the street or right next door to the site. There were amenities as large as a ShopRite or a Trader Joe's or a smaller pizza place and bodega. So there are plenty of options within short walking distances.
And public transportation options?
All 5 sites were located close to bus lines, most of them with the bus stop literally in front of the site or on an adjacent street, a 2-minute walk away. They're also all located close to train stations that would be available or would be easy to walk to and give you access to other towns.
And just a brief summary of the neighborhoods where these sites were located.
I would say they're all more urban and developed than the Bronson Road site. The Sterling Tower site is at the edge of downtown Derby, so it's a pretty urban center. The Cove Road Stamford site was also It was also a very, very urban, very, very tight developed space. The Maple Court Apartments were on the edge of Stamford, so it's a little bit less developed, but still a busy residential neighborhood. And the Darien site is right on the Boston Post Road, so as I'm sure you're used to in any town, it's full of shops, full of stores, and plenty of plenty of movement, plenty of action.
I don't know if the commission has any questions.
I'm just in regards to the public transportation options, mainly the train stations, kind of the only thing that I find applicable here. The way you describe them, there's either walking distance, short distance, long distance. Do you know the distances? I mean, I've only had time here while you were chatting and I was listening to figure out the Darien one is 1 mile, it's a mile walk.
Mm-hmm.
I haven't actually done how far the Southport train station is from this location, but
Right. So I'd say the Darien location and the Stamford to Cove Road station are probably the longest walks. They're probably about a mile, maybe a little bit, give or take. So that's somewhat of a walk and probably comparable to the Southport or walk to the Southport station, but again, still accessible. And the buses also, I'm not positive. I think the buses also may run these routes, making the walk shorter if necessary.
okay, thank you.
Anyone else? Thank you.
I would like to submit to the commission certain site plans that we were able to get with respect to some of these developments, specifically the Derby development on Olivia Street, which is cited as Sterling Towers in Derby. And I would just note, while we could not get a scale drawing from Derby, they were unable to produce a full-scale drawing. There are, once again, 2 driveways accessing the rear of this site. This site is on Elizabeth Street in Derby, so it fronts on Elizabeth Street. It also has a driveway on either side of the building containing the residential portion of this mixed-use building. And you'll see that there's ample parking on the site, but equally significantly, there are wide lanes and wide areas for parking on the site. So I'll submit this full-size copy for the commission. Similarly, in Darien, there's a site plan, and it shows an access in and an access out. The width of the lane in Darien was actually 22.9 between the parking spaces, but once again, it's a one-way entrance, and there's a loop, basically, so it's one-way traffic with, although there's side parking, small side parking area, but generally the site circulation is a loop with a one-way aisle that goes around and back out of the site. And I would submit that to the commission. And finally, on the Fairchild Avenue site that this commission is familiar with, this does have similarly has one entrance, single entrance, two-way entrance in and out, but I do note that the aisles are 24 feet that were presented, and there is no overhead obstruction on clearance. So I would offer that as well.
How long is the driveway on that, Fairchild?
On Fairchild?
Mhm.
Oh, it's relatively short, and while I have a scale, but even scale is 1 inch equals 20 feet, and I have to guess that it's about 80 feet to the, I'm guessing it's about 80, well, no. The first space is literally against the street, so the driveway is literally up against the street.
So between 0 and 10 feet?
Correct, to the first parking space,
Hmm.
yes. And
What about to the building?
from the driveway opening to the building, at its closest point, it's 70 feet. Yes, it's 70 feet to the building, and if you follow sort of along the parking spaces, it's a little over 80 feet to the building.
Thank you.
So the point is that these comparables are not really comparable, and I really think that for the many reasons in that summary, they're not fair comparisons in terms of the parking needs. In other words, the parking needs or the survey that was conducted by whoever 5 years ago is not reliable in terms of what the needs might be on this site, which, as we've said many times, presents a completely different set of parameters than any of those sites that were presented. Okay, speaking of apples to apples, I just would like to address the reference in the materials by the applicant to the use of the Country Club of Fairfield site. And as the commission is aware, that the use at the end of that driveway is a beach pavilion, which is used by the club for, and it's used by the club on a very limited basis. It's not a residential structure, it's a recreational structure. It's apparently open roughly from Memorial Day to Labor Day because it's seasonal. It's not resided in like the project that's proposed, which is, 24 hours a day, 7 days a week, 365 days a year. This has a limited use. It has a paved driveway. It doesn't receive its access from a busy road like Bronson Road. It's not 25 feet, and the entrance into this driveway is not 25 feet from an entrance to an interstate highway. The road to the pavilion is generally straight to gently winding. It does have some bends in it. There are no significant turns as are presented by this application. There are no curbs such as the ones that are presented in this application. There are no sightline issues at all, unlike the present application, in terms of the drive and the bend in the drive. And significantly, there's an easy turnoff onto a generous sandy or grass area on either side of the driveway, unlike here where there are curbs proposed by the applicant. If you have to, you can pull off onto the fairway, and clearly there are no fairways here. Emergency access is not a problem. There's a designated fire lane at the, there's a choke point along it where I think there's a water course that's crossed, and there's a fire lane created there. There's a cul-de-sac at the far end of the parking lot serving the pavilion, unlike in the present application. It's a low impact use. So once again, I don't think that this comparison it's not remotely comparable for all those reasons, and I would urge the commission not to rely on that. I would like to take a moment now to address the CAM application that's included, and preliminary to that, I would like to address some comments that were in the conservation approval that are in your materials. And once again, for the convenience of the commission. And once again, for the convenience of the commission, I produced pages 57 and 61 from the applicant's materials, and I would like to direct the commission's attention, and I've placed an arrow. Under anticipated impact in section 3, there was a stated need for significant cleanup of debris all along the watercourse banks. And what it says here is, much debris over the many years of occupation or farming of this property has been tossed over the bank and into the watercourse or embedded into the watercourse bank. Photographs of this debris, including water tanks, wire fencing, tires, jagged metal, toilets, etc., was presented at the public hearing. The obvious surface debris is an indicator that more substantial debris disposal may have taken place into and adjacent to the watercourse for long periods of time. This debris should be removed, and the debris should be removed after demolition, but prior to the initiation of new development disturbance on the property, to ensure that careful and sensitive attention is placed on the watercourse banks, and to ensure that these areas are restored and stabilized prior to any focus on a development proposal. It's so that excessive vegetation removal does not occur. I would then direct the commission to page 61, which is the second page, and it says that it requires that the applicant submit revised plans indicating, and it says, clear notation that the initial activity on site after structure demolition shall be cleanup, removal to off-site of all existing debris on site in and along the steep inland watercourse banks, not within Mill River, including visible embedded debris causing minimal site disturbance under direct continuous site direction by the third-party environmental site monitor. And there's discussion about filling in any voids and that sort of thing, and replanting that follows. Now, understandably, this is a document that deals with the jurisdiction of the Inland Wetlands Agency, and that is inland wetlands. And this site presents certain issues that relate to tidal wetlands and inland wetlands. So the jurisdiction is split, and in another instance, it's actually the jurisdiction of the DEEP, as this commission is aware from the first night of this hearing. So the next thing I'd like to bring to the Commission's attention is the fact that there is a barn, or there are two barns, and I'm referring to the site plan prepared by Godfrey Hoffman Associates. It's drawing 1 of 1. It's dated June 7, 2013. It was a survey, and it's updated April 29, 2014. And there's a barn depicted on the site. So as the Commission is aware from looking at the survey, there's a barn. Significantly, a portion of the barn hangs over the 100-year flood boundary line. And I'm going to produce some photographs that show the back of the barn, and there are supports for the barn that actually extend into the steep bank behind the barn. and that's below the 100-year flood boundary. So I'd like to present the commission with exhibits from the Inland Wetlands hearing. And these are a series of photographs. And unfortunately, these were scanned, so they're not as clear as I might like. But you go through these photographs, and I know you've received them today, and you probably leafed through them, but you can see that there's a significant amount of debris, and you can see pictures of tires, and if you've walked the site, you recognize the house in one photograph, and you can see tanks embedded in the bank, and what looks like some sort of a fuel tank or a propane tank embedded in the bank. And I recognize that it's difficult to tell where on the site this is, but then there's a photograph that shows the back of the barn, and you can see the columns and the posts of the back of the barn and the steep bank, and you can make out a fair amount of debris behind the barn on the bank of the river. And there's also a shot that shows the back of the barn specifically straight on, and you can see the garbage and debris that staff was referring to on the site.
So, Mr. Green, you're suggesting, Attorney Green, you're suggesting that cleanup should be the water's edge?
I am suggesting that cleanup of the site should certainly be an overall objective. And there's been a discussion, there was a discussion about creating public access on the site, creating access to the water course and that sort of thing, that the public would be welcome on the site. But certainly I would suggest that having all of the various classifications of debris which were described presents a hazard, and clearly it should be an objective to have this removed as part of any use of the site. But I will go one step further. Certainly children living on the site after it's developed, or whoever may come to visit, would be attracted to the water and would be using that area of the site and on the banks. And so I would suggest that that is a safety issue by virtue of all this debris. It's an eyesore. Now, I'll get back to this in a moment, but there seems to be a misconception in this case about what the boundaries are of the property that is the subject of this application. So I provided the commission today with a copy of the deed to the property, of the Connor property in particular, and I think we had produced the Irwin deed the other night and put that in the record, but I'm going to offer the deed of the Connor property and submit that to the commission. And significantly, and I've highlighted on the second page, that I submit that the actual boundary line of the property to the east is the center line, or the former center line, of the Mill River. And that is important. And in fact, if you look at the survey that Mr. Blumenthal was just looking up, it in fact states on these, it says, property line, former center line of Mill River, there's a line that's drawn. And sort of a, hold that up for the commission, line is here. This is the actual easterly boundary line of property. Once again, the easterly property line, or boundary line, shown on the survey is the former center line of the river. It's shown here. It shows a couple of lines from And forgive me, Mr. Chairman, for not addressing the commission only, but if I can. Similarly, on Trinkus grading utility plan, while it's not completely shown, there's a legend that says property line or notation, property line, former center line of Mill River, and this is drawing 3 of 8 by Trinkus dated April 25, 2014. Similarly, and consistently through the drawings, it's shown on Trinkus sheet 2 of 8, the overall site plan. There's also a notation that says property line, former center line of Mill River. And I guess the northerly boundary is the non-access line of I-95. So there seemed to be some confusion on that, and in the DEEP letter, which was dated July 8th, I was sort of surprised to see in the second paragraph that there was a statement by DEP, by Crystal Kallenberg, in the letter to Mr. Wendt, again July 8, 2014, that said the subject property is an approximately 2.9 acre developed waterfront parcel in Southport located between I-95 on-ramp to the north, the Mill River to the east, and the Metro North Railroad line to the south. And there's then reference to the fact that the site is under an order and stipulated judgment with Connecticut Deep to clean up and remediate chromium industrial waste located southerly on the opposite side of the Metro North Railroad tracks. And, there's then a statement on the second page that says, no work is proposed along the banks of the Mill River or in the vicinity of tidal wetlands. All site work and grading will occur at the top of the slope above the riverbank within the currently developed portions of the site. And I was curious about that statement because I thought that it did not indicate an understanding that the boundary line of this property was actually the center of the river. And so...
Is that the letter that was revised or?
Yes, then the revision, I have a copy of the revision for the commission if you'd like, and the revision does not address that issue. It does say...
Well, you mentioned in your reading from the first letter that the property is subject to remediation order.
Okay.
That part was corrected.
Correct. So what happened is in the July 9th letter to Mr. Wendt by Crystal Kallenberg, it is stated, with respect to the issue of remediation at and adjacent to the site, we would like to clarify the point of where remediation is to occur. While it is correct that the subject property is adjacent to the Mill River, and that X site is under order by Connecticut Deep to clean up and remediate the lead contamination, the Mill River is not, it says the Mill River is not a part of the subject application. No work is proposed to take place under this application waterward of the coastal jurisdiction line, which demarcates OLS, Office of Long Island Sound's direct permitting jurisdiction, and that Exide and Superior are not part of the subject property, as our July 8th letter may have erroneously suggested. And then there's some discussion on public access requirements. I'll submit copies of that.
Well, we have that. That's in the record. If you want to, it's fine.
Yeah, I get a hard.
Okay, thank you.
It's easier to read. Mine.
Got it.
It's easier to read.
We got that one.
So
Mr. Chairman.
So first of all, I would ask this commission to specifically ask this applicant, and this applicant has spent a considerable amount of time looking at this site, and this applicant has a number of consultants and counsel who are very familiar with the remediation of the Mill River as a result of the contamination of lead and chromium by Exide, and or maybe Superior, I'm not sure, but if any portion of this site is part of the cleanup,
I think this is a very significant.
I would urge the commission to ask that question pointedly. I would next like to share with the commission.
Mr. Chairman, could I ask a question?
two drawings that were provided to me by Conservation.
Can I
Sorry,
ask-
Commissioner Francis.
What's the significance of the word former in the Mill River reference?
As I understand it, it was an alteration of the contour of the river, and I had heard some discussion of when the bridge was installed, or I'm not sure, but there was an alteration of where the center line is. Where the center line was at the time that this deed, the original deed that deeded to the center line was created, is no longer the center line of the river.
And where is the deed line?
Well, it's an interesting question, and generally speaking,
Easterly or,
there's a lot of law that deals with rivers move, and there's erosion, and there's, I think it's called accretion, where materials are deposited. Some lots grow, some lots shrink, and frequently they're shifting sands. I'm reminded of sometimes down at the beach, surveyors have this problem as to when to determine the area of a lot, because frequently mean high water, by virtue of storms, mean high water can shift significantly on any given day or after a storm. If a lot of sand is deposited, then after that storm event and for some period of time, undetermined period of time, mean high water actually moves. And it's a very interesting area. And similarly with rivers, the center line of what the river may have been 10 years ago or 100 years ago is something that shifts. But apparently there were coordinates sufficient to establish the former center line of the river, such that the survey that was used by this applicant and all of the site drawings used by this applicant actually showed a line that was the former center line of the river.
well, some of the Mill River has to be remediated right in this area, correct?
Well, I'm going to get to that.
And some of this property is under the Mill River.
That's my position is that a portion of this property is under the water portion, or has the Mill River flowing over it. So I would like to present,
Another interesting point to that is the deed, Commissioner Alessi was just pointing out to me, and I was going to ask later. The deed says the parcel is 2.76 plus or minus acres, and
Yeah.
other references refer to it as a 2.9 acre parcel.
I've seen 2.6, 2.76, 2.9, I've
Right.
seen approximations, I've seen 2.74 on certain drawings. So apparently, the dimensions of this property have changed at various times. So
You-
I'd like to
you-
present this drawing that was, it's a diagram of the potential dredging depths associated with the remediation of the Exide property, and I would like to submit it.
Okay, Attorney Fallon? Yep, please.
I'm glad that Mr. Green is streamlining his presentation, but we can stipulate to a lot of this, save the commission a lot of time, and hopefully move this matter forward. We fully stipulate to the cleanup program. We would stipulate that it's probable that a portion of the property that Exide is under the order, as Ms. Kallenberg's revised letter of July 9th indicates, is property that may be part of this parcel that we had no, or our predecessors had no provision in contaminating, but it is totally irrelevant in the context of this particular application. But if it helps move things along in this streamlined presentation, we all know this is part of the public record. This is the consent order with DEP. I'm just trying to find a way we can finish this tonight.
Well-
Okay, that's, I'm sorry, Mr. Chairman.
No, I don't think any response to that is necessary. I mean, I'm presuming that you are moving through we're obviously not slowing you down. You can, please, make your arguments, submit your papers.
I'm going to move right along.
Yeah,
This is-
at this point, I don't see any issues in us finishing tonight.
Thank you. So this is the same drawing, and this is Joel Green trying to draft the appropriate boundaries of this property, just to depict where I believe the approximate location of this property is. I don't claim that this is accurate, but I urge the commission to compare this document and the contours shown with the site, and it's not scientific, it's just to sort of guide the commission into the neighborhood. Now, I think that Attorney Fallon raises a fair point. Because how is this relevant, and what is the importance of this, and why am I getting into this? I'm getting into this because when I read the CAM report that's before this commission, and coupled with the DEP letter, but significantly, the CAM report did not make any reference of this historic and massive cleanup that's going on in the Mill River. Now, there was no mention of removing all of the debris from the banks of the river. There was no mention of, once again, the remediation. And there is a notation that the plan will include the planting of a significant native habitat, so the landscaping plan shows plantings in the area of the barn. The barn is going to be removed. The barn is on the banks of the river. And first and foremost, the CAM report that was prepared is improperly premised on the notion that the site is bounded by the Mill River. And I refer the commission to pages 38 and 39 of the CAM report. And on page 38, it says general site characteristics. It says, the site is located in the Southport section of Fairfield at 92 and 140 Bronson Road, located between the I-95 on-ramp to the north, the Mill River to the east, and the Metro-North Railroad line to the south. And then it makes reference to a steeply sloping, well-defined bank at the site's frontage on the Mill River. So apparently, when the CAM report was done, the assumption or basis was that the site bounds on the Mill River. It doesn't. Then, down at the bottom of page 38, well, just once again on page 39, under 4.1 Tidal Wetlands, the approximately third paragraph down says, the easterly boundary of the site fronts on the Mill River. Now, the presence at the bottom, going back to 38, it says the presence of coastal resources at the subject site was determined through field examination as well as a review of the official coastal land resources maps. There's no notation made of the fact that the whole shore is littered with all this debris. It's not in the CAM report, but significantly, at the top of page 39, it says, based on site conditions and a review of official resource mapping, the following coastal resources occur on or adjacent to the site. It says tidal wetlands, freshwater wetlands, coastal hazard areas. There is no reference made, as defined in 22A 93.7, of a freshwater watercourse. So the actual river as a resource is not noted in the CAM report. So the assessment in this CAM report does not account for the fact that 25%, or I don't know the precise percentage, I imagine the applicant can provide that a large portion of this site is in the river. So I would submit then that a lot of the findings, and for example on page 41, no work is proposed along the banks of the Mill River or in the vicinity of the tidal wetlands, and that's under Coastal Consistency Review 5.0. Certainly there's work proposed along the banks of the river. The barn is going to be removed. Those posts are in the river. The debris should be removed. And this was not covered in the CAM report. And at the bottom of the page, no work will be conducted within coastal waters or below the high tide line of the Mill River. Work is confined predominantly to the currently developed portions of the site. Well, that's true. But I don't think it's genuine not to note somewhere in a CAM report the massive work that's being done in the Mill River, including on this site. And at the bottom of page 42, under CCMA Adverse Impact 5, there's a statement, all work is being conducted within existing developed portions of the site. That's not true. At the top of page 43...
Where did you see that? What was that?
I'm sorry, at the bottom of bottom of page 42, in CCMA Adverse Impact 5. It says, all work is being conducted within existing developed portions of the site. And at the top of page 43, in order to provide additional habitat and buffering to the inland wetlands, the plans include a significant native habitat restoration area that will further screen views. Well, screen views of what? The junk and the debris that's on the bank of the river? Clearly, if this vegetation is being planted in this area, it would be an objective to remove the debris and the materials that are existing there. And at the bottom of page 43, just above 6.0, coastal use and policies, the proposed site work will not occur within or immediately adjacent to these tidal wetlands. The tidal wetlands exist along the water, and it says all site work is proposed within existing developed portions of the site. So there are findings that this commission must make with respect to its CAM review pursuant to 22A 105 and 22A 106 of the Connecticut General Statutes, and in fact, there are certain findings that this commission must make about potential adverse impacts of the proposed activity on both coastal resources and future dependent water development activities. Well, there's a series of criteria, and I know that this commission has dealt with CAM reports in the past, and without getting into detail, and in order to move along, I would submit that the CAM, by leaving out this resource and analyzing the particular resource being the river, that the CAM report is incomplete and not one that this commission should adopt or approve. Moving on, as I understand it, the application is, for all intents and purposes, submitted, and that there are no new materials that will be coming in at this point, as we're this far down the track. But I'm struck by the fact that no materials were submitted by the applicant, and no guidance on, for example, the easement that I had described on the first night of my presentation, being, you know, the situation where the proposed driveway would require, for example, residents of the Kovacs property to take advantage of an easement. There's nothing that's been submitted that I'm aware of that suggests that any of the owners have consented to the application, being owners of other properties, being Metro North or Kovac. And in fact, I've confirmed that Mr. Kovac, the owner of the property at 76 Bronson Road, has not consented and won't consent to this application. There were some materials, and I'm just going to touch on a few areas just briefly before I conclude. There were some materials submitted by the applicant on the issue of the inadequacy of the road and likening this to a subdivision, and there was some suggestion that a subdivision may not be, a legally configured subdivision may not be denied based on the adequacy of the road. We have submitted a brief, and I would submit to the commission that that is not analogous at all to a situation where you're proposing a massive 8-30G project on a road that is inadequate and presents us a series of public health and safety issues, as we spent a great deal of time discussing last evening. We have provided the commission with a listing of code sections to carry all this home, I am going to provide you with Mr. Wendas. So I would urge the commission, as you review this application, to refer to some of these sections in the massive document that we've provided. You have it electronically now by email, you have it on disk, and I think many of these sections would be of great interest in assessing this application. Similarly, I will provide the commission with another copy of the memo that we submitted this afternoon. And I'm not gonna read it, but I think that from the number of applications that have been before this commission recently, I'm sure that the commission is developing a working familiarity with the requirements of 8-30G. Let me say this. We've set forth this standard in this memo. I hope that the commission will read it. I'm sure that Attorney Fallon and Attorney Brantz will provide you with ample argument on the burdens and what's required under 8-30G. And I'm going to ask you to do this in assessing this application. I would ask you to use basic common sense in assessing this application. And, you know, we are each advocates for parties, and what I'd ask you to do is consider the arguments. But it occurs to me that if you have questions about this, you know, we are all advocating, we are presenting the law to the best of our ability. But if you have questions, I would urge you to review questions on the burdens, on what's involved, on the legal standards with the town attorney, and to seek his counsel. And I know it's hard when lawyers are presenting or advocating and presenting the law. I do, once again, know that you've heard a lot of this already, so I respect that, and I respect the time that this commission has already spent on this application. But just in terms of matters of common sense, I just want to throw out, for example, that a minimum of 20 feet does not mean 20 feet necessarily, and I think we spent a lot of time on that, and I won't spend any more time underscoring that. Code enforcement is advisory, it's informational, it is not binding on this commission for obvious reasons, and I think when we concluded last night, we discussed that. You've heard from the town engineer. You've heard from the fire chief, followed up by a former fire marshal. Once again, common sense would dictate the use of this site in terms of the traffic, trips in and trips out in general. Experts use standards, and experts provide you with trips and travels, and they cite sources, and they provide you with this general sense of, you know, of what the numbers provide. But if you live in this town, and if you just put aside the experts for the moment and think about our lives these days, if you have kids, if you're involved in activities, if you're running errands, and if you, this weekend, for example, think about the number of times you come and go from your house. All the things we do, errands, activities. If you're on a board, body, or commission, you're adding 2 trips, like as this zoning commission has done. If you bring in food, if you forgot something, it's interesting if you start tracking the number of times you come and go from your home in terms of trips. And so when experts speak about the morning peak, I get that, and that really is something that deals with maximal loads on roads and that sort of thing. But I think common sense, especially these days, and especially with a site such as this, would lead you to, as a matter of common sense, suggest that this would be a high traffic use on a proposed 20-foot driveway. I'm just going to say 1.2 spaces per unit, and I will say is plainly ridiculous for a development configured in this way. I won't revisit our long discussion last night because I know we spent a lot of time on it. Once again, I'm going to ask you to consult with the town attorney if you have any questions. I think that there's this specter with the notion of affordable housing, but it's really, I don't think it's that complicated in this instance, and I think that this case is fairly clear. I'm sure you'll hear a lot on rebuttal, but I would just ask you to fairly consider the facts. And once again, I just want to go back to the beginning of my remarks before the commission and say this. This is once again not a referendum on the need in our town for affordable housing. It's not a referendum on the overall need. We are working towards a solution in this town. A lot of good people are putting, a lot of creative and thoughtful people are putting a lot of creative thought and spending a lot of time trying to address this issue. And we will address this issue as a town. But this is not the development that addresses those needs by any reasonable standards. And we urge the commission to deny this application. In closing, I think it's interesting, and I should note for the commission that when I speak of those creative, thoughtful people who are spending a lot of time, the Affordable Housing Committee of this town, who are people who are really dedicated and once again has spent a lot of time and a lot of effort on this topic of affordable housing, are not taking an official position on this development. And I have an email that I received that was sent by Stephen Grathwall, who is the chairman, and I will submit it to the commission. And I would say in closing that the applicant might argue that this means nothing because they're not taking a position on this application. My clients and I would suggest that it means a lot. And I want to thank you for your time. I don't know if you have any questions for me.
Does anyone have any questions for Attorney Green? No? Very good.
Thank you very much. I appreciate
Thank you, Attorney Green. At this time, I would like to open the floor here to any members of the public who wish to be heard on this item. Please, come up, state your name and address for the record. Please keep your remarks succinct. We've heard a lot, and we don't need to hear it over and over again.
I know you have, and I'll try not to be repetitious. J.D. Hannanen, 735 Knapp's Highway, just a few blocks from here. Now, I'm not an elected official or a politician here speaking on behalf of any group. I'm not an attorney passionately advocating for either side. I'm not even a resident of the immediate neighborhood here. But I feel, having listened to every day of this hearing and every day of the previous hearing, that if we are going to be one community in one town, then I also feel almost compelled to speak out. Now, I have to tell you all, I have a tremendous respect, growing every day, every night, for all the work that you are doing, and all the millions of words that are put before you, and all the miles of print that you're going to have to wade through. It's astounding, the obligation that this statute and the courts have imposed upon this volunteer body. So I think everybody in this room, no matter what position they take, just applaud you. And I know it's been said before.
Thank you.
I think you deserve it. I think you deserve it. And I have to tell you, I came to the first hearing. When was it? The spring? When was it? The winter? I think the snow was on the ground. I came to the first hearing in this marathon of affordable housing hearings with an open mind. I didn't know anything about the law. I didn't know anything about any of the applications. I saw the signs. I said to my wife, let's go and find out what this is all about. So I came with an open mind. And I came with the feeling that this town and the towns and cities in Connecticut should embrace this concept of affordable housing with open arms. And it's an important goal, and we've heard that from both the passionate attorneys for either side in this particular case. But what has really disturbed me, and it disturbs me with every hearing that I listen to, is what appears to me to be this predatory development that is using as a tool the laudatory goals of affordable housing to force and cram these high-density projects into sites where it would be evident to anybody that they just don't belong. How can anybody, I'm not a traffic expert, and I'm not an engineer, but it just seems to me that anybody that would have listened to all of these words cannot understand how it could be proposed at this site with this high-density 95-unit project. So this commission has the duty of being a quasi-judicial body, I think it is, and you have to sit as judges on this. And then on the other hand, the law says, and the case law says, well, not only are you the judge, but you have to be, in some respects, the advocate. You have the burden of proof also. So, to some extent, it almost seems we're through the legal looking glass here. I'm not sure what the courts and what the statutes expect from you. I am somewhat concerned as to when and how the town itself and the town experts are going to draw the line and take a stand on some of these issues and give you the support that frankly, I don't see you receiving. Maybe you are, but I don't see it. And it is of great concern to me when last evening the fire chief, whom I respect, and I respect all our firefighters, the fire chief has to be subpoenaed to this hearing in order for this body to know his position and to get the benefit of his expertise. So, from my point of view, it seems that the town ought to be doing more in terms of helping this body on these important cases. This is not a run-of-the-mill variance or area variance or something of that nature. These are enormous projects that are going to have long-term effects on this town. In these neighborhoods, where I live, if a mess is going to be made or allowed, I can avoid it. But in another respect, it's my neighborhood. Each one of these is my neighborhood too, and it's all of our neighborhoods. So we have to be concerned, and I resent the concept or the suggestion that is made or implied over and over again that the immediate neighbors who come out in opposition are somehow NIMBY, or somehow they don't want those people, they don't want affordable housing. Well, it's not going to be the housing, even affordable, is not going to be real inexpensive after all. But that's not why these good people are here. These good people are here because the project just doesn't fit. So what is the standard? My understanding, trying to listen to all these attorneys and even looking up a few of the cases myself to try to figure out what the standard is. And you're smiling because you've probably been scratching your head over that and all the different instructions and guidance that you're supposed to follow from these courts. Well, it's not just an evaluation of, as I understand it, evaluation of expert testimony or the evidence. It's not a preponderance of the evidence. It's not a reasonable probability that there's going to be a hazard. It's something more than a possibility. Now, what does that mean? You got me by the sneakers. I don't know what it means. But what I think it means is that there has to be some rational evidence in the record that there is an increase in danger, a hazard to the community, and that hazard is going to outweigh whatever benefits will come from this particular project. And if that's the standard, I don't think this is even close. I don't see how this could possibly be close. And it's not just a matter. I appreciate what Mr. Green has said about applying your common sense. Well, by all means, apply your common sense. That's what you're here to do. Apply your everyday experiences from your own life. Apply what you observed yourself from going to the site. Apply all of that. But on top of that, you have, I don't know some of the other cases that maybe went to court, and there's always this this suggested threat here that, well, if you don't do what we want, we're taking you to court. Well, let them take you to court. The town ought to let them take these cases to court and take a stand and take it to Superior Court, take it right on up the appellate process if need be. But I resent this suggestion, this implied threat that you have to do what we say or we're going to take you to court. And I appreciate Attorney Fallon's eloquence and his passion and advocacy for his client, but I am concerned and maybe even a little resentful about the hubris there. And I think if you just look at the record and what's in this record, you have more than a mere possibility that there's going to be danger here. And it's not just any one thing, and as far as I'm concerned, I'm not an expert, but it's this accumulation of all these things. And you've heard from the fire chief, you've heard from experts, and you've heard from their experts. So maybe the experts disagree, but I don't think if it's a tie, it goes to the developer. If it's a tie, it goes to the opposition, because if it's a tie, then there is more than a mere possibility of this substantial danger. So I think I'm about finished. Have I taken up enough time? I know that a fellow by the name of Emerson once said, "Nothing so astonishes as common sense and fair dealing." So I would say, in conclusion to this body and to any reviewing court, astonish us.
Thank you. Any other member of the public wish to be heard?
I'm used to Commissioner Barrett's. I know he's got that hook under there that if I go too long, it's coming out. I know that. I just want to clear up a couple things that haven't been talked about. On Monday, I asked Annette Jacobson.
I'm sorry, can you just state your name and address for the
Jan
record?
Reber, I'm sorry, Beaumont Street.
Thank you.
I asked Annette Jacobson at Conservation on Monday to correct the notice of decision that you got from Attorney Fallon concerning inland wetlands intervention. It was not a unanimous vote. I believe have you received that, Mr. Wynn? I think that's important. You'll see in my written submission that the statements made by various commissioners about the lack of testing by the applicant really brings up lingering environmental concerns, and you'll see that in the record. Secondly, and I think importantly, I just want to make a couple points about the applicant's qualifications to operate an affordability plan. They've submitted and they're already operating under a 2011 affordability plan for their Fairchild development. It states, "The administrator shall provide notices to the Fairfield Planning and Zoning Commission and local and regional housing authorities. Their notices about the initial availability to be advertised, who's going to live in this facility, what's their categorization, etc. The Fairchild building is about to be occupied. No notices have been provided to P&Z, to Fairfield DECD, or the Fairfield Housing Authority as of last week. I inquired in person at all of those agencies. It seems to me that the applicant, which we don't know, and you should know, what is the pool of residents that are going to live in that location? I think that the applicant is already ignoring the affordability plan that it's supposed to be operating under. Secondly, in my written submission, you'll see some information about coverage of a HUD removal of funding for Garden Homes development in Stamford. Their development in Stamford failed 2 consecutive physical inspections in 2009 and through 2010. The coverage seems to indicate that there were some serious violations. Mr. Friedman took responsibility for those violations. One of his proposed remedies was to bring in an outside property manager. I hope you'll ask some questions of this and every subsequent applicant to to find their violation history and be assured that the applicant is qualified to operate an affordable housing development in Fairfield. I have a concern about the lack of sidewalks at this proposed development. There will be a severe isolating impact on the disabled and the elderly if they're denied sidewalks to walk and to travel by wheelchair outside their residences. This may be a violation of the Americans with Disabilities Act, and approval of this plan without ADA-compliant sidewalks could result in litigation for the town. I've attached a summary of some of the relevant ADA requirements, but regardless of them, we should not deprive the elderly and disabled residents of their right to free movement, and we should not expose them to safety hazards just because the applicant wants a narrow road with no sidewalks. I think the applicant's traffic report fails to establish safe sight lines for when vehicles on the road that will be in the vicinity of the area where the Kovacs vehicles will back out. There's no sight lines established in their traffic report. I think it's a danger when you're looking at the way vehicles will back out of that driveway as vehicles are coming around the curve from the building. As a Fairfield citizen, I'd like the applicant to explain to all of us under what authority he can appropriate and move a town road without, at a minimum, approval from the RTM. I'd also like to know what his authority is to take away the current right of persons using the Kovacs property to directly access a town road without the need for an easement from a private party. Finally, I'd like to address some statements by Attorney Fallon and by Attorney Brands that I think have mischaracterized the public in Fairfield and why the public is here. At the Inland Wetlands hearing, Attorney Brands, rather cravenly, I thought, waited until rebuttal to announce that the Fairfield audience consisted of, quote, sudden environmental advocates, unquote. That audience actually consisted of people like Joy Shaw, who spoke here last week and is widely known for her Riverlab program. Attorney Brands flippantly mischaracterized that entire audience. Not a single person who spoke at Inland Wetlands, not a single person who spoke in here, spoke out in opposition to Garden Home's Fairchild application. Fairfield is not rising up against affordable housing. This Bronson Road application is fatally flawed for the spectrum of reasons you've heard. In his introduction, Attorney Fallon said that Fairfield pays, quote, sincere lip service, unquote, to affordable housing. Attorney Fallon's oxymoron is confusing. You can't be sincerely hypocritical, at least as far as I know. I've attached a timeline beginning in 1964 and running through this month of some and only some of the steps Fairfield has taken to house and assist the homeless, the elderly, the disabled, and the economically challenged. Our momentum to provide additional affordable housing is growing. We are sincere. In conclusion, my sense is that Attorney Fallon is characterizing this application as a referendum on affordable housing. It's not. It's a zoning application submitted under special regulatory circumstances, but it's still a zoning application. It's not a referendum. Thank you.
Thank you very much. You can just hand the whole packet and we'll pass it around. You can just hand the whole packet. Yep, thank you. Yeah, very good. Hi there.
My name is John Wynn. I reside on Harbor Road in Southport. I believe this application should be denied. I've summarized in a two-page letter my concerns, and I've provided that to the commission. I will not read the letter, yet I wanted to highlight in about a minute or so the key points that are more extensively detailed in the letter. I find three issues that are apparent. First is traffic. The applicant's assumptions are not grounded in fact or reason. I'll describe that. Waterfront usage. The simple dismissal of the idea that the area would not have any use for water or commercial activities is not plausible. Third issue is there's a town-wide public safety danger. This development, if allowed, has the potential to divert and unreasonably tie up public safety resources, endangering all residents of the town. The first point I wanted to make, the traffic issue. The cornerstone is the number of trips. What might such trips be? Representative categories of trips would include work, shopping, errands, addressing the needs of parents, children, or friends, personal trips, visitors to residents in the location, or deliveries. Just those 7 categories of trips. If you do the simple extension of 7 categories of trips, 2 trips and 95 units, you get 1,330 trips, which is 3 times the amount of trips that the applicant has indicated, which was approximately 400. So it just doesn't make any sense. The traffic, if you just look at those standard categories of activities that we all undertake, and I've described that in my letter. The second topic related to the water use and commercial use. There are definitely going to be commercial and personal water use activities. There are a variety of businesses that do kayak rentals, canoe rentals, tours, bird watching tours, etc. And the public use is quite extensive. If you look at the Tide Mill Bridge, anytime in the spring or summer, there's extensive fishing going on. So you know this facility is going to have public use activities going on, which is going to increase the activity, the trips, and consume the parking spots. The ultimate impact is the already unsafe traffic volumes and patterns are going to make a public safety problem at this location. My third point is there's a town-wide danger here. This facility, this development, when completed, will wind up constricting public safety resources when they respond to either potential events or events at that site. They're going to get tied up and they're not going to be able to get back out and redeployed in an effective manner, which is going to impact every resident in this town. So you're going to be putting the residents in this facility in danger, you're going to be putting the first responders in danger when they respond to that facility, and then because those people can't get back out to serve the community or address problems on I-95 right there, the entire town is going to be subject to a public safety problem because of the logistics issues at this facility. I've detailed all of this in my 2-page letter. Thank you for your service. Thank you for listening. I appreciate your work.
Thank you. Hi there.
My name is Jeanette Sikora. I'm at 45 Hulls Farm Road in Southport. I am just on Hulls Farm, 2 houses off of Bronson. I oppose the current plan for the 95-unit apartment building and wish to present my thoughts. I believe that multifamily housing is appropriate for that particular site based on its location right next to railroad tracks and I-95. If someone were to build a new home, it would be very expensive and they would not want to live in that particular location. I do have 25 years of experience in driving around town on 20-foot wide roads, making me a possible traffic expert. These narrower roads can be safe except when there are hills, tight curves, except when 2 wide vehicles pass side by side, except when a vehicle parks on the road, except when 2 vehicles and a bicycle or walkers are 3 abreast on that road, except when drivers are on their phones, except when there is a ditch or a big tree on the side, except when drivers are impaired or in a big hurry or when they think they are better than anyone else. The suggested parking spaces are inadequate. A high percentage of the residents would have more than 1 car. There's no other convenient overflow parking. The nearest side street is not too inconvenient, but it's steep. Winter parking would be an issue and a problem. I did my own rush hour traffic study yesterday. I'd hoped to park on Bronson and observe while parking, but it was not possible. The road was not wide enough for parking, and moving to the side would entail driving over the square profile curbs. Driving on them would ruin my tires. Traffic was quite heavy in both directions right at the proposed drive into the development in the morning. If half the residents in the proposed project would try to leave the area for work between 7:30 and 8:30 in the morning, approximately 50 cars would line up to enter Bronson Road, approximately 1 a minute. The normal heavy traffic that's already there would hinder exiting the development. Drivers would then rush to drive out, possibly causing an accident. People in a hurry to get to work or come home are not considerate of other drivers. The low-income residents might not even own a car and would need to use the Post Road bus service by walking there. No sidewalks are planned. I personally own buildings with 101 total apartments. Tenants are always on the move. This 95-unit building could have anywhere from 0 to 10 units vacate every month, and of course, new people coming in, possibly causing constant disruptions in parking and traffic. I heard a guess that there could be possibly a total of 400 driving trips daily. I'm not sure if this is total trips or total of both directions, but I knew I know there can be a lot more. I personally left my own home 3 times today, and my husband once, so a very common occurrence. That makes 8 times up and down my driveway. 700 or more trips in and out of the apartment complex each day would make Bronson a pretty big mess. I believe this committee is planning and zoning. I hope I'm correct. I've heard that there are state rules for low-income housing that destroy all local zoning rules. Supposedly, the only way you can deny this particular petition is to show a public danger, so I'm saying our traffic study expert and fire chief made excellent presentations in that regard. There would be a danger to the town. However, there is still the subject of the architecture. The style is a bit unique. The intense colors are not found anywhere else in this town except for the builder's other in-town project. This project would be a hindrance to my health because the design makes me sick. Allowing this project would continue a precedent that's already started, and the colors would continue to destroy the personality of our town. I oppose the approval of the proposed project because of the housing density on the land and because the design is inappropriate.
Thank you very much. Could I just have a show of hands? How many of members of the public anticipate speaking? Okay. Thank you. Yes, sir. Hi.
Good evening. My name is August Sarno. I live at 55 Mill Hill Road in Southport. I am speaking here tonight as a town resident and also as a professional architect. I am a licensed Connecticut architect, a member of the American Institute of Architects with over 35 years experience in designing, reviewing, and evaluating properties for development. For the past 20 years, my experience has been concentrated in the design review and site evaluation of proposed multifamily housing developments, mainly within the state of Connecticut. First of all, let me state that I am a strong advocate of affordable housing development that is thoughtfully and reasonably designed to the site and the neighborhood and the conditions surrounding it. Based on my review and analysis, however, the proposed site plan and building design at 92-140 Bronson Road is not reasonably designed for this site, has major public health and life safety issues that have not been considered in responding to the existing conditions both on the site and the surrounding environment. The proposed 4-story building with garage parking located on the first floor level is sited within 10.5 feet of the property line abutting Metro-North Railroad. I would like to present, I did file copies of my presentation earlier.
Yeah, we did receive that. Thank you so
Okay.
much, yes. And that was helpful to have and read
Okay.
beforehand.
The articles I presented, and you have a copy of, are basically 3. One was a New York Times article dated May 17th, 2013, indicating 2 Metro-North rail trains collide after derailment near Fairfield, Connecticut, injuring 60 people, 5 of them critically. The 2 other articles, one Liberty Voice and ABC News, dated December 1st, 2013, indicate Metro-North derailment killed 4 early this morning. For your review, please review this for your review and consideration. The proposed location of the apartment buildings within 10.5 feet of the railroad is a life safety issue. I have prepared a building section, and I can just hold that up and maybe face it towards the audience, that shows a section through the building and the relative distance between the building apartments and the train. You can see that the level of each of those departments are within close distance to those railroad trains. And if an accident had occurred, such as a derailment, the life safety of those people would be in jeopardy. In addition to the possible derailment, we're looking at a constant noise issue. 24 hours, the train traffic on this railroad, I believe there are about 45 trips between Grand Central Station and New Haven. And I'll just list the times of those events. The schedule indicates that there are 45 trains starting at 12:07 a.m. and continuing to 11:23 p.m. that pass the site. 11 of those trains generally go on an hourly basis and are considered off-peak and pass the property between 9:35 p.m. and 4:05 a.m. And this schedule does not include the Amtrak or Metro, the freight trains or Amtrak trains that would travel at greater speeds and much longer duration. The ability to rest and sleep during hours between 9:35 and 4 a.m. on an hourly basis is a health issue related to the residents directly in line with the trains. The health and life safety along Metro North Railroad, I looked at other properties, one of which is located in Milford, Connecticut at 27 Golden Hill Street. This property, it's called Golden Hill Apartments. It is owned and managed by Garden Homes Management. And in reviewing that property, I have some photographs that I presented to you, and I also have available that shows a safe buffer zone between the railroad property and the apartment building of approximately 50 feet. I believe that this property, if it is developed, would need a buffer zone similar to that provided in Milford on their property. This zone would restrict construction of any building but would allow parking on the site. It would also require that the existing mature and protective trees along Metro North be maintained. The purpose of the safety zone would be to reduce the risk of human loss or injury and mitigate the disturbance, both noise and ground movement, caused by the train traffic. So, at a minimum, I ask the Commission to consider a 50-foot life safety buffer between the Metro North Railroad and this property. The existing house currently located on site, based on the existing site plan that was submitted, is about 82 feet from the Metro North property. The existing mature trees currently there seem to have been planted about the same time in the early 1900s that the dwelling was constructed. These trees act as a natural protective buffer between this area, and that's why they should be maintained. All life safety zones similar to that at Golden Hill should be provided for this site. In addition, I would like to comment on the proposed site and building design in the context of the surrounding neighborhood and community where the property is located. The surrounding area is residential in character, with single-family residences, a duplex unit, and one multifamily condominium development containing 25 units. The height of the residential buildings in the existing neighborhood range from 1 to 2.5 stories in height, that are approximately 12 to 25 feet. The proposed 4-story building will be approximately 50 feet in height. The neighborhood is zoned residential and is physically separated from the commercial zones by the Metro-North Railroad. In reviewing the proposed development as designed, the height of the proposed building is out of character and scale with that of surrounding neighborhood and residential buildings. In comparing the differences of building scale, I refer you to a drawing that shows the footprint of the building and to visually gain an idea of size. The dotted line represents a football field, which is within goal to goal 300 feet. The length of this building, scaling off the drawing, is approximately 298 feet in length and 135 feet in overall width at the widest part of the building. It just about fits lengthwise and widthwise in that football field area. The need to accommodate on-site parking requirements in a city result in residential dwelling units being elevated over parking areas in order to satisfy parking and to achieve the intended number of parking units. I visited several properties similar to that proposed at 140 Bronson Road, which are also owned and managed by Garden Homes Management. They are all located in the central downtown area in the city of Stamford. The properties are Summer Street Apartments, containing 89 units, 5 stories, 111 Prospect Street Apartments, 55 units, 5 stories, and 25 3rd Street Apartments, 50 units, 4 stories. The proposed 4-story, 50-foot high building, 298 feet in length, 135 feet in overall width, based on the height, massing, and density, is typical of buildings located in downtown urban centers such as Stamford. The design criteria and the site's surrounding condition for multifamily residential development in downtown Stamford are very different from designing a development on a 2.74 acre residential site in Southport. The volume, the range, diversity of activities, including retail, restaurant, shopping, offices, and other service-oriented businesses, are unique to the downtown area of a city. City sidewalks, traffic controls, are key design elements that encourage pedestrian travel for residents living in these central downtown areas. The proposed site and building design is one that will cover over 70% of the developable property with impervious asphalt paving, underground storm drainage, retention systems, catch basins, and concrete footings. State Statute 830G references reasonable development with regard to public health and life safety. It is my professional opinion as a Connecticut licensed architect, based on my review and analysis indicated above, that the proposed housing development at Bronson Road is not reasonably designed for this site and does not provide the basic protection of health and life safety for its intended occupants. Thank you.
Thank you very much.
Good evening. My name is Signa Wenberg Merritt, and I have been asked to read a letter from Mr. Charles Merritt that was written and submitted to the commission this morning.
Yeah.
And I will be brief.
Yeah, thank you. But you don't need to read the letter verbatim.
Thank you. There were 5 points that were made by Mr. Merritt that are primary health and safety issues. The first being that Mill River Area 1 contaminated with Exide battery and Superior plating site is too close, unhealthy, and unsafe for 95-plus apartments and inhabitants. The second is there's only a 20-foot wide driveway. We've heard lots about that. The third is there's only 116 parking spaces, which are not enough. We certainly have heard a great deal about that. We've also heard Mr. Sarno speak of the potential derailment in the proximity that is too close. And the Interstate Route 95 on-ramp is not only too close, we haven't considered the off-ramp that is probably within 500 feet. As a 29-year resident of Southport, I support affordable housing in our neighborhood. Garden Properties proposes nominal affordable housing within this project. Given the plethora of health and safety issues raised within these hearings, I'm concerned with the, quote, minimal standards for safety, as quoted by Attorney Fallon, compared to the reasonable safety considerations proposed by numerous experts and residents. In the same spirit of, quote, goodwill, I would hope that these issues also be forefront and center to all potential residents prior to signing a lease. As a Fairfield Public School educator who drove past this point every day for over a decade, as well as the parent of 2 children who attended Mill Hill School, I'm seriously concerned with the fact that not only are there no sidewalks proposed on the property, there are no sidewalks on this side of Bronson Road. There are no sidewalks nor room for sidewalks on Mill Hill Road. As an educator and a parent, our children of Southport depend on us to ensure their health and safety. I urge you to be the voice of reason and deny this application. Thank you.
Thank you very much. Thank you. Hi there.
Good evening. I'm Jack Franson. I'm a Fairfield resident. I'm an architect. I live at 2760 Congress Street, and my office, one of my offices is at 95 Harbor Road in Southport, so I do go past this site a lot, almost every day. We heard last night serious concerns from both of the fire safety experts, both Fellner and Ackley. Both stated that the proposed 20-foot road that's designed is not safe. And that's based upon hard-won experience that they referred to with existing projects in town. The fact that some standards indicate a 20-foot dimension meets the minimal requirements should not confuse the fact that this is a really long road. It's got a sharp turn in it, and it terminates in a development where there's no possibility of backing other than backing a vehicle out. There's no cul-de-sac and there's no hammerhead. I imagine there could be a 20-foot driveway that would be safe if it was short, if it was straight, and if there was a means of turning a vehicle around. But that's not the case here. In light of what I said above, I think it's pretty obvious that under extraordinary circumstances such as a fire or a medical emergency, that this is an unsafe project. But what about ordinary day-to-day circumstances? Every day when I go past that site, if I'm a little late in my routine, there's a conga line of cars blocking the off-ramp of I-95 because there's a school bus. And you can only imagine what's going to happen when that school bus gets in front of this development and people are going to work and trying to leave it. There are relatively few instances that I'm familiar with in the Fairfield zoning ordinances that are explicit having to do with safety. Most of the zoning regs are about amenity, functionality, regulation of bulk, etc. But the newly adopted bike and pedestrian regs that I'm very familiar with because I served on that commission were set up, and they state basically the purpose is to promote safe and efficient ingress and egress, circulation for bikes and pedestrians, that sort of traffic, including direct and convenient circulation between main entrances of buildings or uses of the site and available to points of access in and out of the site. And clearly in these regs, it's implicit that a site that's designed without separation of pedestrian and vehicular circulation is not safe. And in the same regs, if you go on, that town now feels that what is safe is to have a 5-foot sidewalk with a 2-foot snow shelf, or in lieu of that, a 6-foot wide sidewalk. So I just don't see the safety here for kids going to school, people who are in wheelchairs. You can imagine what it's going to be like in the snow, and all this has been mentioned. But how the design of the proposed road, with all of its length, its proximity to a bike route, which just got approved and the lines got put in and the signage got put in recently, the school bus route, and one of Fairfield's most walkable communities with no pedestrian means of connection. It just escapes me how this could be safe. Thank you very much.
Thank you, Mr. Chairman. Thank you. Do you have one for staff? Is this, okay, then you can, yeah, thank you. Please state your name and address for the record.
My name is Donna Weisman. I live at 22 Rockview Road. I also am opposed to this project. I won't read the entire letter. Most of it is a variation on what you've already heard. I'll do two things which I haven't heard at this meeting. One, any estimate done should be based on maximums, not minimums, since there is no overflow provision possible. This is true for parking as well as traffic. Using minimums creates an unrealistic statistic. The traffic history in this history has been an increasing number, not a decreasing number. How will parking be adversely affected by a heavy snow year? The true reality of the parking needs cannot be determined until after the building is completed and fully rented. Therefore, using maximum estimates is essential. Concerning safety, should an evacuation of this area be required for some reason, how will all these people, as well as the residents already in the area, get out? Has this plan been done? An evacuation could also be needed in a fire situation, which our chief discussed other problems in that area very well, or a bomb scare. Can all the necessary equipment and the process of moving all these people be done in a timely manner with only one way in and out and limited space within the facility? Thank you.
Thank you very much. Does anyone else wish to be heard on this item?
Good evening.
Good evening.
My name is George Wiswell. My wife and I live 130 Willow Street, Southport. We've been residents of Southport for 50 years. My comments will be quite brief, and I hope you'll consider them quite significant. Last night, I enjoyed listening to the fire chief on his concerns on the entry into that area. I also call your attention to the crowded conditions at exit 20, both east and westbound during commuting time. It's tight. There's no room for more traffic. Within the last 6 months, I've been blessed, if that's the term to use, to have to call 911. And in so doing, I know the procedure. And in talking to both the fire people and the police that come to the site, they pride themselves with exactly how long it takes them to get to any part of the town. And it's a procedure that they send 3 vehicles. The fire rescue vehicle, which is the 9-foot wide one that the fire chief talked about last night, the ambulance, and the police car. All for a purpose, because they don't know what they're going to encounter when they get to the residence where the problem might be. But to get those 3 vehicles in there to that location could be a most difficult thing. And I know from experience that time measured in minutes and seconds is most critical. I'm here. I'm appreciative that I'm here. And I'm appreciative of the service that I got from fire, medical, and police on the 2 occasions I had to call them. You can't squeeze things into spaces that they won't fit into, at least if you're in a rush. Thank you for listening to me.
Thank you, sir.
My name is Barry Morey. I live at 668 Bronson Road. That's about less than a quarter mile up. It's on the riverside. I've lived at that residence for 63 years. So I don't think there's anyone in this room that has been up and down Bronson Road more than myself. Also, I live on the river. I've used that river since I was a child. I know everything about that river and the area. So I would just like to describe to you my typical morning as I leave my house on Bronson Road and back out of my driveway with my 1996 Honda Odyssey 4-cylinder car. I usually wait. I have a view of the stop sign at Mill Hill Terrace and Bronson Road. By the time I have clear enough path, wait for maybe 4 or 5 cars coming on their way to work from Greenfield Hill area, using Bronson Road to either get on 95, mostly not going the way I'm going toward Bridgeport, but to go through Southport and get on 95 going towards Stamford. Anyway, typical morning, I wait for that traffic. There's someone at the stop sign. I'm able to back out and make my way towards 95. I get on 95 at the exit 20 entrance ramp every single day for the last 25 years. Normally, by the time I am at 6 or 7 houses down, the people coming from Greenfield Hill are right on my tail. Normally I have to put my brake lights, it's just because they're coming so fast. And I, being a neighborhood resident, want to abide by the 25-mile-an-hour speed limit, which I don't. I'm going a reasonable 30 to 35 miles an hour, which is normal, and they're still on my tail. Then when I approach the entrance to the I-95 entrance that we've all been talking about, which is directly in view of the exit, the proposed exit from the new site. Traffic is coming, the other traffic is coming from Southport. I have to negotiate whether they're going to get on the entrance ramp in 95 or continue up Bronson. Sometimes they'll have a signal on, so I know they're going to get on 95, and there's, kind of a dual entrance, one from the north and one from the south. So I get past that. Now, rarely have I ever seen a car come out of this entranceway because there's so few residents down there. Now I'm imagining cars trying to come out from that new driveway And between 7:15 and 9:15, I would say you might as well put a right-hand turn only sign at that spot, because you're not going to get out left and go up Bronson without a long queue coming out of that driveway, because there's just too much traffic, mostly going toward Southport, but some coming north, coming north on Bronson. And that's all I'd like to say, that I consider that a safety hazard for myself, coming down there, having to wait now to negotiate a third entrance coming in, and having them almost rear-end me almost every day when I get on that entranceway. Thank you.
Thank you. Thanks for your comments.
Hi, Krista Grant. Actually, I live at 78 Bronson Road in the duplex that shares the driveway with this new project. I was not going to speak tonight. However, with what he just said, he's right. I try to get out of there in the morning, try to get to work. Can't take a left. I have to take a right to get right on the highway right there. 9 o'clock in the morning, I have a Monday morning, for instance, we have a garbage truck trying to get in. Do you know that garbage trucks only back into this driveway because pulling in forward, they can't get out otherwise? So they back down, they sit right in between 92 and our duplex and block the way right there. They can't get in or out any other way. With everything that's been said, I'm not going to harp on any of it. But what about our safety in this duplex that shares this road? This road that's been here for over 100 years? What about us and our tenants backing out into this road with this curve going to this project, this 20-foot road, with their tenants coming in and out, going around this curve, as we're supposed to back out onto this easement that they're creating for us? That's really all I have to say. Thank you.
Thank you very much. Do you just have something to submit?
I'm just going to be handing out a letter.
Okay,
It has to do
please.
with parking and precedent. I have.
You can just submit it to staff. We'll pass it around.
Thank you.
Thank you very much, Ms. Braun.
Good evening. My name is Peter De Silva. I live on Mill Hill Road. Thank you all for your service to the town. I just wanted to speak as a constituent of, as the fine gentleman spoke to people before, about the beneficiaries of those who the fire department in specific creates when they talk about the life safety issues. About 11 and a half years ago, 3 o'clock in the morning, my smoke alarm went off. I smelled a little bit of smoke, called 911, went outside, saw flames leaping out of the side of my house, called 911 back again, said there are flames coming out of the side of my house. Within 3 to 4 minutes, the first truck from Southport Volunteer Fire Department came, followed by Engine 4, followed by all the other in-service vehicles except the 2 ladder trucks. They just came to my house, a residence. We heard Chief Filner say before about the timeliness and how important it is to get and attack the fire. In my particular case, the fire had been burning in an outside attic and then in our main attic for apparently quite a long period of time. When the Fairfield firefighters attacked our fire, they did it in such a phenomenal technical way, not according to me, not according to, I'm just a homeowner, but according to the 2 state arson investigators, the state police arson investigators, as well as the investigator from our insurance company. And they said, your firefighters did a phenomenal job. They said, 2 more minutes, your whole house would have been what they call a flashover, flames everywhere. So within the 2 minutes that those firefighters were able to quickly drive down Mill Hill, drive up our driveway, begin to prepare a stage and put out the fire, they were able to do it in such a fine way that it prevented loss of life and also significant loss of property to our house. So we heard Chief Fellner talk about the timeliness in order to go and help someone who may have a fire emergency. I'm here before you to say that is just not a number that he pulls out of the hat. It's not an FLPA type code. It is a real life event that I am here because of, and he, I'm sure, drove from his experience in his 55 years as a fireman, as a lieutenant and then as a fire chief, when he came before you and he said he believes that this application as is presented is unsafe. So, as someone who's benefited from his wise counsel before, I just ask you to really give a lot of weight to what our fire chief says, not the national code, because that's just a small subset of what chiefs follow, but what our chief had to say about this particular application. Thank you again for your time. I appreciate it. Good luck.
Thank you, thank you. So, could I have a show of hands? I'm trying to wrap up public comment. I think we're just about finished. Is this possibly the last member of the public who wishes to be heard? I think so. Oh, we have one more, okay. Well, you can come up, address your questions to the commission, and if the applicant might choose to answer that in rebuttal, but that's fine.
Okay, my name is Ed Zigmont. I reside at 60 Kings Drive. Traffic, we hear the traffic concerns. We heard on Bronson Road. Kings Drive is another cut-through. It's in the immediate area. It's a speedway. People utilize Kings Drive to bypass the lineup of cars to get off, that are getting on at entrance 19 off of the Post Road. When the traffic backs up there, they shoot down Kings Drive. The additional traffic from this project would also enhance those numbers. Regarding, you heard plenty of information about from the fire chief. Some of the research I did, the width is 20 feet unobstructed. The clearances and the width can be increased for the fire apparatus of the town. The other issue is the turning radiuses. The turning radiuses shall be maintained. There are some tight turns in that project from what I had seen, and also a dead end requirement. Even though there is a dead end, the apparatus will have to get in and turn around. But even when they do turn around, they will be gridlocked by other apparatus that are backed up. The evacuation issue. In recent years, Kings Drive was evacuated because of an incident on I-95. It's a fairly light neighborhood. All the emergency resources were tied up at a major truck accident and fire. How are they going to evacuate an additional 95 units? Thank you.
Thank you, sir. Ma'am?
Hi, I'm Janine Alianello. My question's kind of for the town. Has anyone from the town consulted the American with Disabilities Title II regarding the use of recreation and things in the scope of this project? Because I don't really understand access to disabled people without sidewalks or certain drop-offs, and especially if you're going to have recreation area. I'm not a lawyer, but it was concerning to me since my brother's niece is bound to a wheelchair almost her whole life, and she has to live in New York City because she would not be able to participate in anything around here. So I just didn't know if the town does have some obligations with those two disabilities. So you can ask that. Thanks.
Thank you very much. Any other member of the public wish to be heard on this item? Excellent. Attorney Fallon, rebuttal.
Mr. Chairman, if I could just have 2 minutes to kind of straighten things out, and I promise you, with the hour
Very good.
that we're at, we will have no problem finishing tonight. I would suggest that the commission wanted to take like a stretch your legs, because I think if I get organized,
I think that's a good idea. We'll stand in recess for a few minutes. Call the meeting back to order. Attorney Fallon?
Thank you, Mr. Chairman. For the record, John Fallon. First of all, let me say I want to thank my colleague, Mr. Green, for his professional representation of his client, as always. I want to sincerely thank the members of the public. I've been here for 38 years, and it always amazes me as I travel from town to town how we in Fairfield set a standard, I think, for civility. and intelligence, even with the applications that are heartfelt on all sides. The members of the public always conduct themselves with dignity and respect for one another, and I sincerely do appreciate that. And lastly, of course, as we approach this 14th hour of our hearing, maybe we're moving into 15, I do want to sincerely thank the Commission for your time and diligence and interest with regard to this application. I'm going to try to sum up tonight. I have some witnesses I want to bring back and call and rebuttal. My intention is to move through this expeditiously and certainly with assurance that we hopefully, depending on questions you might have, will be finished with this, I think, long before the curfew. My hope is that if we make this presentation to you in rebuttal, we'll be able to answer any questions that you might have during the course of that, but obviously we're here to answer any such questions. The first thing I want to talk to you a little bit about, and it gets to the standard, and I'm not preaching the law now, but as you know, what you have to ultimately determine is whether or not there is substantial evidence in the record that the decision, assuming that you were to deny this, was necessary to protect a substantial public interest in health or safety. And the part I want to dwell on right now is that such public interest clearly outweighs the need for affordable housing, and that such public interest cannot be protected by the imposition of reasonable conditions of approval. And the way the statute works, it's your right and burden to look at the application and establish those conditions of approval. We don't have to do that. But at the same time, we respect the process that we've been through here. And we do, in fact, want to be responsible in terms of some of the things that we've heard. So we're going to suggest to you 4 conditions of approval. And I give them to you now because they will relate, at least in part, to some of the testimony you'll hear in rebuttal. I would like to offer those 4 conditions. I don't know if Mr. Green has any objection. I can read them, but it seems to me that...
Not subject to his objection. If you have some suggestion, hand him a copy and submit it to staff.
So there's a copy here for everyone. And as I said, the reason I do this at this point in my presentation is I think it relates to some material here. The first thing, and I won't read these in total, but is in accordance with what was pointed out at the hearing, correctly, that 5 handicap parking spaces, not 2, as shown on the site plan, are required. We would propose, as a condition of approval, that 3 additional handicap parking spaces be added, and that will result in a net reduction of 1 space. And that also...
Because they're bigger.
Right. And that also should result, in accordance with the condition that we propose, with the reduction of 1 unit, because we're losing a parking space. Secondly, to accommodate the turning movements for an aerial ladder truck, although we honestly believe that what we laid out does meet a fair standard for safety and operational performance by the fire department, we're eliminating 4 parking spaces, and they're replacing them with a hash zone and 1 appropriately worded sign indicated no parking. Fire department turnaround area. The project shall in turn be reduced by 3 units more due to that reduction of parking spaces. So the first 2 conditions, and our engineer is here, Mr. Trinkus, to review that, will deal directly with the question of handicap parking and the concerns that were heard last night. Now, this is sensitive, and I leave it to the Commission. Mr. Trinkus was working on this later this afternoon. I don't want to raise anybody's blood pressure, including my colleagues behind me, but all this document is, if you want to accept it to the record, is his pro forma sketch that might ultimately save you and your staff and Laura Pooley some work in terms of how we would reconfigure this to affect the reduction in the parking to accommodate the fire area. And
So, very pointedly, you're proposing a new plan with new parking, turnaround, and a smaller number of units?
We're proposing conditions of approval that we can verbally address for the record, and leave it to you if you like to have your engineering department review them. But we offer not a revised plan, but we offer a sketch showing how these two minor, but yet I assume from comments that were made during the course of these proceedings, important matters can be implemented. That's up to you.
Well, it's not up to me. It's certainly not up to me on the fly. I wasn't made aware of this previously. I'm not going to be the gatekeeper and quote-unquote accept. You are free to file or hand in anything you would like to staff, subject, of course, to any objection that might be made, and subject, of course, to any decision we might make. It's up to, that, Attorney Fallon, is up to you.
Well, I will offer it then, and I've given Mr. Reno, I will give Mr. Reno, I offered it to him.
I mean, just to be clear for the record, I mean, I'm not acting as an arbiter as to whether this is acceptable. You've now handed a document into staff. I'm going to see it literally for the first time.
And so the offer is...
You're in rebuttal. You're in rebuttal. Are you
the-
honestly going to...
And so the offer is clear, since you have the responsibility to establish conditions of approval, and since we have offered 4 conditions, the first 2 of which I've discussed, that talk about how this application could be conditioned.
Why should I not consider this to be a proposed modification to your application rather than conditions for approval?
Because it isn't. It's simply offered as documentation of a proposed condition of approval.
Well, Mr. Fallon, by doing this though, aren't you changing the original blueprint that was submitted in the application?
Not unless you choose to do so in your work session and adopt these as conditions of approval.
None of this has been reviewed by any of the engineers. None of this has been reviewed by the public. It's not been reviewed by any of the opposing experts or anything like that.
Our engineers, police department, fire department?
There was testimony last evening at 10:30 at night about 1, inadequacy of the handicap parking, and 2, concerns raised by various people about the sufficiency of a turning radius for fire apparatus.
Yes, but Mr. Fallon, that was based on the application you presented to us some 3-4 weeks ago.
But in an 8-30G application, you have to determine that there are not conditions of approval that you can attach that will remedy concerns of public health and safety.
830G or not, you really want to submit a new application diagram during rebuttal?
I'm not seeking to submit a new application diagram. I'm submitting orally suggestions for conditions of approval.
I'm not sure I agree with that in the sense that you're doing it in the context of rebuttal, which ostensibly does not give the members of the public or the attorneys and their experts, the experts they call, the opportunity to review it and present
Then disregard.
there.
Then disregard.
Please.
Disregard this sketch that I gave you.
You would like to withdraw the submission?
If it concerns the commission as a procedural matter,
I've stated what if you'd like to withdraw the submission, then withdraw it.
And the proposal.
Both things?
Please.
Yeah, I mean, it's already, I think the public, I've already submitted it. You can give it what weight you want. The purpose of the, or not. The purpose of the offer is, though, that we want to make clear for the oral record that we are willing to abide by these 4 conditions of approval. The third one simply being subject to WPCA approval, which we'll talk about later, and the fact that if you determine as a condition of approval that we should not, and I'll read it, at the option of the owner of 76 Bronson Road, the driveway apron serving 76 Bronson Road may be eliminated and the existing paved surface left as shown in the driveway diagram on page 21 of the supplemental materials. That's the Kovacs matter. So all I'm doing, and you can disregard the sketch since if that causes you procedural concern, since you have the obligation, before you could deny this application, of addressing conditions of approval that would address what you think are public health and safety issues, we offer these orally for your consideration, and to
Are you
make the record
conceding
clear.
that there exist public health, safety, and welfare issues that need to be addressed in your application?
Clearly, the WPCA matter is a matter of public...
Not the WPCA.
Oh,
I'm asking you very pointedly, are you conceding that there are public health, safety, and welfare issues that are problematic in your application for which we need to make modifications to your plan?
Absolutely not. I think...
Then why submit this?
Because we are trying to react constructively to the comments that were made.
It would appear to me you're acquiescing to the
No, we're not.
to the concerns and the
We're
comments.
standing by the comments that, the application that we made, and the evidence we submitted in terms of the fact that they address all aspects of public health and safety. Trying to be constructive for these proceedings, we're offering these conditions of approval, notwithstanding our position in that regard, so that they might address concerns that we heard from the fire chief and from members of the public and from yourselves. So it is in no way a new application, and it is no way any admission, tacitly or otherwise, that there are public health and safety issues with regard to the application as we presented it. These are offered for your consideration.
Although you concede that the ADA requires 5 handicap spaces and not 2?
Correct.
So
And
that is a defect
Right,
in the plan.
you have an obligation under the statute.
I'm not talking about that. I'm talking about the ADA spaces.
We agree that we need 5 spaces, 5 handicap spaces, and we've offered a condition of approval to address that at the expense of a unit.
So then you are also acquiescing that we have a problem with a fire truck, an aerial ladder truck.
No,
so you-
I said to the chairman, I don't believe you do, but to the extent that, again, we're trying to be constructive and react responsively to the concerns, we're offering that as a condition.
No, I
But it is not
understand.
meant as an
The-
admission.
The point that Commissioner Alessi raises is that, very specifically, I asked you if you were conceding then that
And I'm not.
that there are issues, and you said, no, these are just proposed conditions.
Correct.
But then we look at item number 1, which is the handicap spaces, and you are conceding
I'm not
that there are
conceding.
5 required under the ADA.
Right, but that's different than the question you asked me. The question you asked me is you're conceding there are public health and safety issues with your application. I don't believe that...
You don't think having 2 when you're supposed to have 5 handicap is a public health safety
I don't
issue?
believe it is, and secondly, even if it was, you have an obligation not to deny an application on that basis, but to condition it with a condition of approval that'll remedy the situation which we have now offered.
So I'm supposed to do your work for you after the fact.
That's what, in this particular instance, that's what the legislature and that's what the courts say, as it relates.
And you're now trying to come in with a proposed amendment to your application.
We're offering you conditions of approval for your consideration.
I think you need to move on.
Okay. What I'd like to do at this time is call briefly back by way of rebuttal, first Mr. Steve Trinkus, who will discuss with you certain aspects of this and what we have. I'm going to have Kermit Waugh come back, and he'll make a response to Mr. Spears' testimony. Andrew Hennessy is here. He'll briefly come back just to testify about questions that were raised last evening from an architectural standpoint and height clearance and the like. And then I have Mr. Joe Versteeg. We've asked to come here tonight. He is very well renowned in the state of Connecticut, Versteeg Associates, as a consultant specializing in the interpretation and application of the building and life safety codes. He will strictly address rebuttal to some of the issues you heard last night. So, I'd like to call on Mr. Trinkus.
Sure. Before you begin, very, very briefly, Attorney Green is standing, looking to be recognized. What's up?
If I may just briefly make just a 30-second statement for the record.
Please, 30 seconds.
It is quite simply this. It is appalling to me that this applicant would submit these conditions, this diagram, particularly in the context of this application where I was required to submit by 1 o'clock today all documents, because Attorney Fallon stated to this commission, let's avoid a lot of back and forth with documents. There is a statutory scheme that is provided under 8-30G that deals with, for example, a modification in the event that an application is denied that allows an applicant to submit a modified plan under certain circumstances.
Okay.
I think that this flies in the face of both.
In light of the submission, I'm asking you to submit something in writing that speaks to that issue.
I'm sorry?
In light of that statute and this submission, I'm asking you to submit something in writing that speaks to that issue, if you would like to do so.
So in terms of the overall objection to this
Correct.
document?
And will the hearing remain open?
No, it will not.
So you're not going, in other words, you're going to give an opportunity for Mr. Green to submit written documentation to the commission as part of these proceedings, but foreclose the applicant to responding to that?
Are you not foreclosing his opportunity to respond to your submission here tonight?
I am not.
What would you propose to do then?
I would simply propose we've offered for the commission's consideration items of potential conditions of approval that arise directly from the comments that were made last evening.
Do you believe that this is new evidence, new argument?
No, I do not.
You don't? You don't believe that Attorney Green or other members of the public should be given an opportunity to respond to the submission?
To the proposed conditions of approval, no, that's within your purview. You can act on those or not.
Well, and Mr. Chairman, I think as a practical matter, I think it's of paramount importance to all of us that the public hearing be closed this evening for a variety of reasons. And
What's the citation to the statute?
well, it's, there's a process in 8-30G, and it's H, and it refers to a situation where a commission has elected to reject an affordable housing application or to approve it with restrictions which have a substantial adverse impact on the viability of the plan, and it allows under certain circumstances an applicant to submit certain modifications. I only raise this because there is a statutory scheme to the extent that Attorney Fallon or his client feels that there are modifications that should legitimately be considered and properly considered by this commission, that there is relief for them. So I think that I agree with what I'm hearing from Attorney Fallon, the ability or the situation that he referred to last evening as a lot of back and forth, that it seems to me that these documents have been filed. I think I would ask the applicant to ask the commission not to consider them, even though they are in the record, and we strenuously object to them being considered and in the record without, as the chairman had referenced, our ability to review it with, for example, Mr. Spear, who's not here this evening, an engineer that I might have consulted with, or indeed the fire marshal or the fire chief on the proposed turnaround and so forth. So that's all. I'm going to note my objection. As you're aware, the process is governed by the rules of fundamental fairness. I would suggest that introducing this document at this late date is not fair, and I leave it to the good judgment of the commission.
Very good, very good. No, please move on.
Mr. Chairman, for the record, first of all, there's a matter here in terms of my personal integrity, and secondly, there's a matter here of the legal protection of my client. Number one, I would endorse what Mr. Green said earlier. You may want to consult with your town attorney.
You can be sure I will.
With regard to that. Number two, without belaboring it, all we did was offer to you 4 suggested conditions of approval for your consideration. You can reject them or not. You can never look at that sketch, or you can. You can discuss those conditions of approval amongst yourself and with your town engineer. You can do anything you want. But because the statute does say that you can't deny an application if there are conditions of approval that can deal with concerns that you have about public health and safety. And since those things came up last night at 10 o'clock, we simply offered those 4 items for your consideration. It is not like we came in here with a new plan.
But you did. You sat there for 2.5 hours with that in your bag. You didn't give it to me. You didn't give it to staff. You didn't give it to members of the public. You didn't say anything about it.
I did not feel and don't feel it was something.
And that's fine. You've said your piece for the record. Attorney Green has said his piece for the record.
Fine.
Move on.
Mr. Trinket.
Good evening again, Steve Trinkus. I'm a licensed professional engineer in the state of Connecticut with an office in Southbury, Connecticut. What I'd first like to discuss is the 21-page document that was filed with the commission on Monday by Garden Homes Management and has 3 sketches in the back, pages 19, 20, and 21. I just want to walk the commission through those 3 sketches. On page 19, the first sketch shows the limit of the 25-foot right-of-way and the limit of the existing driveway from Bronson Road that serves both the Kovacs property and the other house, the subject of this application. The right-of-way, as we've said previously, is 25 foot wide. It goes from the right-of-way at Bronson Road.
So just so you know, none of us are looking at what you're talking about now because it's not been submitted as you said that you would.
Electronically, but hard copy is yet to be submitted.
Oh, I'm sorry, I have hard copy.
Right, I didn't print it because the email said hard copies would be forthcoming, so I figure we waste 2
And I will
pages.
just wait till Attorney Fallon
If you're-
hands those out.
Right.
Thank you.
Yeah, I'll never hard.
What page in this submission are you
Page
talking about?
19, Mr. Chairman.
What page?
Page 19 is the first sketch.
Please continue.
Okay, the first sketch on page 19 basically shows the existing conditions, the limit of the 25-foot wide right-of-way and the existing driveway which serves 2 residences. The driveway width near Bronson Road is 15.4 feet. Where the parking area is for the Kovacs, it widens out to about 18 foot and then narrows down to a little over 10 feet as it goes to 140 Bronson Road. We've also highlighted in the heavy line, that is the DOT non-access line. So again, this just sets what the existing conditions are. If you go to page 20, this is an enlargement showing again the right-of-way line and showing as double parallel lines our proposed edge of curbing for our 20-foot wide road. Connecticut DOT, at the time we laid this out a year ago, required us to maintain a 1-foot separation from the corner of their non-access line to the back of our curb, and that's why the line is offset from that corner. As you can see, there is only 25 feet of frontage along Bronson Road, so there is no way you can put a road wider than 24 feet here because you'd be impinging onto the non-access line. I believe it was Mr. Spear last night talked about that the curve return went into the non-access line. The curve return does not. That is the curve line that bears to the top right of the page. That's within the road right-of-way of Bronson Road. That's the town Fairfield right-of-way. It does not encroach on the DOT non-access line and is permissible. It is routinely done anytime we have a proposed driveway. The third sheet, page 21, is a kind of a combination. It shows, again, the existing driveway with the overlay of our proposed driveway. Originally, as part of the plan set, and you'll see it as a hatched area, we were going to have our 20-foot wide driveway coming in, and at the point the driveway was opposite the access area to the Kovacs property, leave or put in a new paved apron, basically mirror what was there but give them a new apron. What we're proposing by this sketch is that as our driveway comes in from Bronson Road on the left-hand side, is when it hits the edge of the existing driveway that serves the Kovac property, that's where our curb would stop. So we would not create a separate line through there. We would leave completely their existing driveway exactly as is. When you get to the southern end towards the bottom of the page, right opposite their name Kovacs, where the driveway begins to narrow, at that point we would reestablish our curb line and maintain our 20-foot going into the property. So we would leave whatever access they have within the right-of-way exactly as they have it, and there would be no issue with any easement. Going towards to the sketch that Attorney Fallon just submitted, We highlighted the two modifications as conditions of approval in red.
I was told not to look at that. I don't understand why I'm hearing argument about
Well,
that.
Then I will bring the site plan, and I will point it out on the site plan.
Are we considering this?
Are we considering it or not? Is that the same thing we got in the sketch?
I'm going to refer to site 2 of the project plan set, which is the overall site plan used. I'm using sheet 2 of the project plan set, which is in front of this commission. The 3 additional handicap spaces, as Attorney Fallon mentioned, as a condition of approval, would be located.
I don't understand. Are you proposing to add 3 handicap spaces to your, to amend your plan? Are you proposing to amend your plan?
The record should indicate that we have offered conditions of approval for your suggestion with regard to the handicap parking compliance and also with regard to...
You made that clear. We just talked about that, but I don't understand. Then,
To the extent that the chair doesn't want any fuller discussion of how that may be laid out, we can leave that to your staff and your town engineer to look at.
if you're proposing amendments to your plans, then it would make sense for you to explain that, but if you do that, then I think you're throwing a procedural wrench in this whole thing. You're submitting an amended plan.
And after the time everyone has spent here, that's the last thing I want to do. So we'll leave it that we've orally suggested conditions of approval for your consideration. And to the extent those might embody modifications to the site plan, that's something you could look at with your town engineer and your staff. But we are not seeking to amend the application that's before you tonight. Thank you, Mr. Trinkus.
Unless there's any questions, I'm done with my testimony.
Does anyone else have any questions for Mr. Trinkus? Thank you.
Thank you.
Mr. Waugh would come to respond to some of the comments made by Mr. Spear.
Good evening, Mr. Chairman and members of the Commission. Again, Kermit Hua, KWH Enterprise LLC, Meriden, Connecticut, the traffic engineer for the applicant. In the interest of saving time and moving things along, I'll try to be as brief as I can. I will cover 2 things. One is responses to Mr. Spear's comments. The second is I will give you a brief summary of the traffic findings. Comment number 1 from Mr. Spear's letter essentially deals with the land uses. Apartment land use number 220 versus apartment, mid-rise apartment, which we are using, land use 223. I disagree with Mr. Spear's recommendation of using apartment, which is a more general category, includes mid-rise apartment, but on top of that, it includes other types of apartment in both urban and suburban settings. Just for that reason, I feel that's not appropriate. The second reason I feel that's not appropriate is I looked at a parameter called the standard deviation of the 2 sets of data. The standard deviation measures the variation dispersion of data from the average. So in other words, if it's relatively high number, you have data points all over the places. If it's a relatively low number, you have a clear trend of data points, which is more preferred. The standard deviation number for apartments is 0.73. The standard deviation for mid-rise apartment, the land use we used is 0.56. So in this, if you look at this, the mid-rise apartment data obviously is a preferred solution application in this instance. Comment number 2. Again, he talked about we need to adjust the capacity analysis based on that trip generation of using mid-rise apartment, which I don't agree. So I feel there's no need to change our capacity analysis in comment number 2. Comment number 3 is about the calculation of parking, essentially 1.2 spaces versus 1.5 spaces Mr. Spear quoted from a book by ENO Foundation, which is a private foundation. The source I use is from the Institute of Transportation Engineer, which is an industry standard. So, like any professions, there are industry standards and there are other things. I feel in this instance, Mr. Spear quoted a source from these other things, which to me, at least as a professional engineer, does not have as much standing as a publication from the ITE, Parking Generation 4th edition, which we used to come up with that 1.2 space justification. As the commission may be aware, on top of that, we also have 4 surveys of similar uses, similar apartments in the area. Comment number 4, accident data. What Mr. Spear used is accident data for the ramp he got from DOT. My position is we are contributing very little traffic from the apartment. Go ahead.
How many accidents did you say were in your report?
3.
And how many did Mr. Spear say?
We're looking at 2 different, we're looking at 2 different locations. Mr. Spear was looking at the on-ramp. I was looking at Bronson Road, on which we have the driveway.
The on-ramp is 25 feet from your entrance.
No, on-ramp is from the intersection of ramp, just by definition, intersection of ramp with Bronson Road, all the way to the intersection of ramp with the main line. Does that make sense? Well, that's my understanding of definition of on-ramp. In any case, my argument is we are contributing very little additional traffic to the on-ramp, and also it's not really related to our driveway, because we have driveway on Bronson Road, not on the on-ramp. So our data from the police department.
Wait a second. I'm looking at this report, and I see 1, 2, 3, 4, 5, 6, 7 accidents at northbound access from Bronson Road. That's exactly what it says. It doesn't say on 95. It says at northbound access from Bronson Road.
Northbound access ramp.
At northbound access from Bronson Road. That's what it says.
Well, so you think that's the intersection, not the ramp?
Well, that's what I would say. Vehicle turning left from proper lane.
Well,
vehicle going straight. Vehicle wrong side of the road. I don't think that's the entrance ramp.
2 things. One thing is, at least that's not covered in the town police reports.
But I have 7 or 8 accidents here where you stated 3.
Like I said, we are talking about 2 different things.
No, we're talking about accidents in Bronson Road. That's what we're talking about.
Right. Those 7 accidents are on the on-ramp, not on Bronson Road.
No, that's not what it says. It says at Bronson Road.
I disagree on that point.
No, you could disagree. That's fine.
Comment number 5. Mr. Spear used the data to justify the need for a left turn treatment of sorts to the access road and to the ramp. What he didn't realize is there's a separation of difference between the side driveway and a southbound on-ramp. There are 2 legs of ramp. There's about 120 to 130 feet distance. So what he did essentially to combine the volume of that southbound left turn onto the ramp with the volume southbound left turn into our driveway. So that's 2 separate different intersections. He's combining those 2 volumes to justify a left turn treatment. To me, that just doesn't make sense at all. These are 2 separate intersections. You cannot combine their volumes to justify any kind of left turn treatment. Comment number 6. Mr. Spear claims that the resulting traffic pattern is very undesirable. Essentially, he's talking about the traffic pattern resulted from the development. According to our analysis, our traffic analysis, which we have the detailed output sheet as part of the traffic report, all the intersections we studied are operating at level of service A, B, or C, and they will continue to do that, and we are contributing very little to incremental increase in traffic delays and changes to those level of service. So the claim of resulting traffic pattern is not very desirable, is clearly not supported by the traffic analysis we have in the traffic report. Comment number 7 is about the queue and the potential of blocking the neighbors' parking spaces at the driveway. according to our analysis, on appendix pages A15 and A19 of the traffic report, the 95th percentile queue for drivers exiting the driveway, that is, if we take samples, the top 95th high sample is less than one vehicle. So I would really not call one vehicle as a queue. So according to Mr. Spear's comment, you need about 3 vehicles to block those spaces. Clearly, that's not a concern based on my traffic analysis, based on the queue data analysis. Comment number 8, that's about site circulation. I think civil engineer has covered about, and I wouldn't comment on that one. Comment number 9, about a 20-foot parking aisle. This also was covered previously by the civil engineer. Comment number 10, I think that's about the fire safety. I'm not an expert on this. I assume Mr. Spear is not an expert on that either, so there are better people to respond to that. I think they have. Comment number 11, 12, and 13 essentially recommend us to contact the State Department of Transportation. There are 2 things. One thing is the DOT Newington office, essentially what we call OSTA. They have a threshold. If it's a residential development, you have more than 100 units, you meet their threshold, what they call a major traffic generator. Clearly, we don't meet that requirement. We are not a major traffic generator, so we are not subject to OSTA review or the Newington office review. The second part is the Conduct District Office 3, District 3 in New Haven. My client had previously, about a year ago, met with Conduct District 3 on this specific project, and the district office didn't raise any questions or any objections at that time. So that's all Mr. Spear's comments, 1 through 13. I just want to summarize our findings very quickly. First thing is, as I said, this is not a major traffic generator. If you compare the peak hour trips from our development with other applications before the commission, you will realize the net increase in traffic is very limited. The second, about safety. We use the town police department's data. There really is no accidents recorded, if you excluding those 2 intersections, on a 1,200 stretch of Bronson Road in front of the site, which our driveway accesses directly. So there really is not any accident concern supported by data. Number 3 is the existing capacity of the road or the existing volume on Bronson Road. If you compare, one of the commission members commented last time, this is an arterial, maybe, but if you compare this arterial with other arterials, say Route 1, the magnitude of volume is just, we are about a half or 2/3 of typical major arterials like road. This is not a busy arterial. This is not a busy road. There is enough capacity for additional traffic on Bronson Road. The final point I want to make is about 1.2 parking, and we based on that our IT standard, we based on our survey in the area, we feel 1.2 parking spaces per unit is adequate. That's all I have.
Thank you. Commissioner Jacobson.
I understand what a standard deviation is, but could you just explain one more time why the medium-sized apartments should be used versus the one that Mr. Spear used?
Right. Mr. Spear used, I think, apartment data. He has more data points, probably more than 100, 200 data points, even since, I think, beginning the earliest data from 1950s. So you have both urban area, suburban area, every part of the 50 states of the United States. I think if you plot those numbers, if you look at those numbers, there's dots all over the place. I just feel, and compare that to the mid-rise apartment. We have fewer data points, 8, I think, but those points are sort of more aligned. So I think that's a better indication of the data quality, I think, at least. Think about it, if we're talking, by the way, the source of the mid-rise apartment, Mr. Spear also mentioned, it was based on a survey in Montgomery County, Maryland. You may argue, Montgomery, Maryland is different from here, but to me, for the trip generation estimation purposes, sort of suburban, near major metro area, there is a similarity here. On the other hand, if you look at the apartment data, you have urban data, you have maybe downtown Chicago, downtown Boston, maybe Florida, Orlando, a lot of apartments have at least three, 2 or 3 apartments. In our case, we only have a studio and 1 apartment. That's something to keep in mind. We have very small.
But your data is based on 7 studies in 1980, is that true?
I think probably, I don't have that right with, it's
That's
about,
that's what it says in the record.
yes. Just by the nature of the samples, this one is called the
But it's
mid-rise
1980.
apartment. Well, his data is from 1950s. You think 1950?
No, they were from...
Beginning from 1950s.
Beginning from 1950, but it extended way up into 2000.
Right. And our is beginning from 1980.
And
It's
where,
not
what locations was your data from? Because this is a big point.
Montgomery County, Maryland.
All of your data comes from Montgomery, Maryland.
Oh, I don't have that page right with me, but I'm pretty sure, significant.
Because that's important.
Right. But, just this data is called a mid-rise apartment. We are mid-rise apartment. Mr. Spear said, oh, forget that, you use apartment. I think that's just against common sense. If there's a source said, we have this data specifically for your land use, and he prefers to ditch that and choose a general land use, I'm not even talking about traffic engineering. I think that's just common sense.
Your data's 34 years old.
So you think,
Correct.
you think from data from 1950 is better than 34?
No, but it starts at 50, but his data goes I read the data, it goes
Right.
all the way up through 2000.
Right. So who knows what's in there?
I do, I read it.
You read a summary, but
Yes, no, I didn't, I read that study.
Okay.
Okay, thank you.
Thank you. Commissioner Barretts.
Yeah, Mr. Wah, I was going to ask you the same question as Commissioner Jacobson. So you don't dispute Mr. Spear's assertion that the using mid-rise data, land use 223, ITA data is based on 7 data points from 1980 Montgomery County, Maryland. You agree with that?
I don't have that in front of me. I have no opinion.
But you
on
just
that.
said Montgomery County, Maryland was the
Yeah,
case.
I remember reading Montgomery County.
Okay. My question is, did you submit, we got a document on July 9th from, it was again nicely packaged together with all page numbers like that. It says calculation of daily average trips by Kermit Wah.
Right.
And it's on page 220.
That was in
224.
response to the chairman's question during the hearing. I said I don't have the menu with me, and chairman said you are waffling. I don't know what waffling is, but I said I'm going to provide you data.
I don't care what he said. I asked you this question that day. Did you submit this? This is based on apartment 220.
Right. The reason I submit that is because there's no daily trip for mid-rise apartment.
Right. That's
So
my question. Why did you use 220 here? This is a document you submitted, and you're using
Right.
the data points, which looks like it has a nice, pretty, not a very big spread in the standard
That's
deviation.
daily, right. So we are talking about 2 things. The thing I talked previously is our peak hour data. We have peak hour data of both mid-rise and apartment.
Yeah.
So my argument is, if you have both, use the land use that describe what you are developing, not a general category that encompasses all area.
But when we asked you for the daily trips, you chose to use 220.
Right, because for the mid-rise use category, they don't give you a daily trip. And the apartment, the chairman asking me, what's a daily trip? So that's the best source I have as an alternative.
I don't mean to
You
include that, but I asked that question.
you asked the question, and I asked him to submit the data point because he didn't have it.
Right.
So that's what he did. And so what I'm getting from this, and Mr. Watt, you can just confirm this, what I understand to be the case here is that the reason that data point wasn't in your initial report is because it wasn't in the mid-rise apartments. You didn't have, that data wasn't in the section that you used. When asked to supply that data point, you chose to use the 220 section because it included the trip generation data point that we were interested in. Is that right?
We were not required to, the zoning regulation doesn't specify, what we are supposed to cover in the traffic study.
No, I understand that, I understand. It was an inquiry that we made.
Right.
Separate from your report. We said, what is that data point? it wasn't in your initial report, whether it was because you weren't required to do it or because you chose not to submit it. When asked to submit that data point, the document you submitted was from the 220 section.
That's correct.
Right. Okay. Is that handwriting on that page yours, by the way?
Yeah.
I think it is, yeah.
Okay.
Okay.
The handwriting actually reflects, it does a calculation. I think this is actually pretty simple. It takes an average rate, and they had 88 studies there, and...
And I also added the trips from the duplex, you know.
Right. They come up with an average rate of 6.65, so I understand your calculation. You multiply that by 95 units, and you get 631 trips per day.
Right, and
So when
plus
we
the-
asked you to calculate your average trips per day, again, you calculated 631.
I think it's about 700 plus or minus.
About 700.
Yeah,
so.
yeah.
Originally, you had submitted this document about very low-volume roads in support
Actually,
of the
that's-
smaller
that-
riders.
that's the civil
And
engineer, yeah.
I guess I think I saw a document from the applicant today that they've kind of recanted using this. They agree with Mr. Wentz' assessment that this is not applicable.
Well,
Is
I
that
think
correct?
because we have new document to support the position of 20-foot driveway, so from
Okay,
the state DOT.
I'm just saying, when we asked you for the average daily trips, your calculation of 700 and the other traffic engineer said there's more, clearly made that the initial document is not applicable whatsoever. You've noted that. Okay.
It's, you'll, as a proposition, you agree with that? Yes. Okay.
Okay. Thank you.
And the record should reflect that Mr. Wentz memo is.
Okay.
Very good.
Because I asked
Yeah.
originally, was
All
it
right.
an alternate
Thank you.
or to
Thank
be
you.
used? So it's not to be used.
No,
Not to be
that's,
used at all.
it's now clear in the
Okay,
record.
thank you.
Applicant is not basing their calculations or argument on a low-volume road. Astro, right.
Excuse me, I had a question also, may I,
I'm
Mr.
sorry,
Chairman?
yes, please.
Oh, I'm
Mr.
sorry.
Cohen.
It's a question for Mr. Hua.
I didn't
Grab you
realize
back for a
that.
second.
I'm sorry.
Okay. On page 234 of your proposal, you've got Table 7, parking demand at similar developments. What time of day was used for this study? At what time of day was the study
As you
conducted?
can see from some small source, like those studies were done by Traffic Engineering Solutions PC and Frederick P. Clark Associates Inc. As I understand it, they counted until very late at night, until everyone at home. So they were able to capture the highest parking numbers. So what they found is, even during those highest parking number period, there are still several spaces left over at all of those 4 locations.
A number of 1 would indicate every unit has a car. So are you implying that across the studio and 1 bedrooms, there are occupants who have no car? See, that's why I question whether this really was late at night. Because you have to think everybody who lives outside of Manhattan has a car.
Yeah. So you're talking about, you're comparing the number of units with what? Like which column are you looking at? Like,
Oh, let's say Sterling Towers,
Okay.
Derby,
so
or Maple Court.
Sterling Tower, we have 51 units, and your question is?
Peak parking demand, a space per unit, any number less than 1 means that there are units without a car. If truly they did the study at night where, people are home for the day.
Right. What was, people probably are not at home, visiting friend out of state, on vacation.
25% of the people are on vacation?
What do you mean by 25%?
Maple Court, I guess it's 76, I'm sorry, I haven't got glasses on, maybe that's 75. That would say that 1/4 of the units had no car in the parking lot that night.
We don't have the sort of a vehicle ownership data here, but conceivably people are not at home, like I said, visiting other places, so they are not at home at night. I don't think that's something we can control.
Are you speculating at the time of day at which this was conducted?
I'm pretty sure they counted until late into night, so captured the peak parking demand.
We really don't have an explanation why so many units had no cars.
I think the only statistic we have is for the one in Darien. We know it's 100% of the apartments, they own cars, and we don't have the car ownership data of the other three.
Okay, thank you.
Any other questions for Mr. Wall? No? Thank you. Mr. Fallon?
I'd like Andrew Hennessy, our architect, to return. He's going to discuss briefly three matters. The fire safety provisions that are included in the architectural design, the question that came up during the course of the hearing about the impact of columns in the parking area with regard to maneuverability, and also in that same vein, the 22-foot aisle width and how it impacts the parking. Andrew. Thank you.
Good evening. I'm Andrew Hennessy. My company is A. Hennessy Architects. We're located in Newburgh, New York, and I am the architect for the project, as I'm sure you know. I'll touch on the first subject being the aisle width and columns. This is essentially one item dealing with maneuverability in and out of the parking spots. It's been in my experience that towns typically in their zoning set that regulation from 20 to 24 feet for aisle width. 24 is typically the maximum. 20 is the minimum I've seen. Normally in towns where it is 20, such as Stamford and some other towns, we normally design to 22 feet anyway, because we feel that's the right number and works well for backing out and maneuvering. Now, as far as columns being there, obviously this happens in every structured parking garage there is. It needs to be held up somehow. So invariably you have some columns near the edges of some spaces. It's not been a problem in my experience in the past, maneuvering in and out. It should be, I'm sure you understand that this is not a high turnover parking lot. It's not a retail type of building or a doctor's office where every 5-10 minutes someone pulls in, pulls out. It's normally someone pulls in, they're there for hours or even overnight, and they pull out. So it's a very, typically these apartment buildings, in my experience, have very quiet parking lots. Now moving to fire safety, I know there was a lot of talk about fire safety, and I want to make sure you understand all of the fire safety systems and technology that goes into building this building that go well above what's done in single family or townhouse type construction. I'll start with just how the building's constructed. The first floor, and including the second floor structure, is all non-combustible, no wood. In addition to that, that non-combustible construction is then fire rated to a 2-hour rating. So the bottom of the second floor ceiling typically gets a sprayed 2-hour fire rated assembly. All the steel is coated, and then on top is a 4-inch concrete slab. The upper 3 floors are built in wood, but typically we do that as protected wood, meaning all the wood is fire rated and not exposed to a fire condition. Now, the way the upper floors are set up in the building in general, each apartment is its own fire rated container. You have 1-hour fire rated walls on all 4 sides, as well as your ceiling and your floor, all fire rated. Now what that means is if a fire were to start in one of these compartments, and if there was no sprinkler system, which I'll get to in a moment because there is, these walls, floor, and ceiling system are designed to resist the passage of the fire for 1 hour. So that fire will be contained to that one unit for 1 hour. Now, in addition to that, the building is fully fire sprinklered. So if there was a condition where there is a fire in one particular unit, the sprinkler in that particular unit would most likely be activated should a temperature reach the level where they are activated, and that sprinkler will go off and knock down the fire. Now, in addition to that, and this is something that you don't get in townhome type construction, is there's a central fire alarm system. So if there's a fire in any portion of the building, the entire building's alarm goes off. So if you're on the fourth floor at one end of the building and the first floor fire or second floor apartment catches fire at the opposite end, you're going to know about it as soon as the detectors pick that up. As well as if there's any flow in the fire sprinkler system, the alarms will also sound. Excuse me. So now these compartments are protected. Every door into the apartment is fire rated and also is equipped with a self-closing device. So you go through the door and the door closes and latches itself. That's part of the fire rating. Now, once you're out into the corridor is also fire rated. Walls, ceiling, floor, again, all rated to 1 hour, and also there's sprinklers in the hallways. And once you leave your apartment door, you have 2 ways to exit. Depending on where the fire is, you'll see which way to go. Normally, you'll head towards the closest exit unless there's an issue, you know you can go back. And you have to remember, these are people who live here for the most part, so they know the building and how to exit. It's not, a transient type of housing or hotel where you're not familiar with the arrangement on how to get out. And also, obviously, it's clearly marked with exit signs that work in the dark and things of that nature. Now, let me just make sure I'm covering all my points. Give me one moment. Now, in each of the stairwells, there's also what's called a standpipe system, which is interconnected with the fire protection system. And what this provides is a hose bib on each floor for fire department connection. The building code for these type of buildings does not really anticipate the fire being fought from the outside. In fact, the windows, as you know, in most residences, in a bedroom, a window is sized in order for you to exit and for a fireman to get in with all their equipment on. That's not a requirement in these type of buildings because it's not foreseen that that's how a fire like this would be fought. Typically, what would happen, in my experience, is a fire truck would show up, they would go to the fire alarm panel, which would indicate what zone the problem is located in. The fire alarm panel is typically in the lobby, and the firemen have access to that, and that directs them to the pinpoint in the building where there's an issue. And then they send their crews there, they have water available on every floor, and typically the fire is under control within that one particular unit that started the issue. I mentioned we have a full fire alarm system. This includes both visual as well as audible alarm. So if you are impaired of hearing, there are strobe lights that indicate that the alarm is going off.
I have a question for you.
Sure.
Have you ever been a fireman?
No, I haven't.
Do you take any fire safety training?
Obviously, we're very familiar with the fire code as an architect.
Do you consider yourself a better authority on fire safety than our chief of 15 years?
I would not make that statement not knowing his background, no.
Okay, thank you.
Are you, I'm sorry, do you need a minute to collect your thoughts?
I just have 1 or 2 other points to make. All the exterior materials on this building are also non-combustible. The materials I passed around during my first presentation, the hardy plank is cement board, and the other metal panels are non-combustible. So the exterior of this building is also non-combustible. So I guess in conclusion, what I'm saying is this type of building is safer than a typical single-family residence. For instance, someone in the audience mentioned about a fire in their attic.
Yes, that was me.
No, that's not appropriate at all.
And
Thank you.
What I'd respond to that, in this case, if there was a fire in an attic of this building, there would first of all be an alarm system, and there would also be a sprinkler there to put the fire out. So the alarm would signal, no need to call 911, they'd know immediately. And the sprinkler would go to work should the temperature reach the limit of the sprinkler.
Can I ask one question, and I may have missed this? Is the parking level, is the parking level also sprinkled?
Yes. The parking level, even though it's an open parking structure, requires sprinkler, fire alarm apparatus, just as if it was enclosed.
Thank you. Any other questions for Mr.
Commissioner Jacobson.
No, that's okay, he answered the question, thank you.
Right.
Thank you.
I have a question about the sound. Is the building being designed in any way to ameliorate the sound from the train that will go by 10 or 15 feet from the side of the building?
Well, I think if you remember from my first presentation, I spoke about our outside wall construction. Our outside walls measure 14 inches thick with 3 different layers of insulation material in there, as well as air spaces. Now, I haven't tested this particular assembly to STC, but my experience from ones we built is it's quiet. In addition to that, we use triple glazed windows, which again limit the noise intrusion.
So you haven't done any testing on how that soundproofs the interior of the apartments? Simple question, yes or no?
No.
Thank you. Anyone else have any more questions?
Are
Thank you.
Are
Commissioner Francis.
are you the person to ask about trees?
Excuse me?
Are you the person to ask about trees?
No, I'm more of the building.
Mr. Trinkus? How many trees are there and how many are you taking down? Speaking of
Thank you.
sound buffers.
Mr. Fallon?
Well, the only thing I would mention is, typical of construction, this is just back to the soundproofing thing, is just a 6-inch exterior wall.
I understand.
So I just want to make sure you realize that.
You don't have to repeat it. I understood what you said. Thank you.
Very good. Thank you. Good evening.
The last person I'd want to call, we spent a good deal of time throughout this hearing, most of last night, I guess, kind of, at least partially, talking about the applicability of fire safety codes. I know the chairman was particularly interested in nailing down some aspects of that. So we have here Joseph Versteeg. Mr. Versteeg, as I said before, owns Versteeg Associates. They're a premier consulting firm specializing in the interpretation and application of the building and life safety codes of the state of Connecticut. And he's just going to address directly by way of rebuttal the information that was submitted, some of it to the record today by Mr. Green, just to kind of give hopefully some worthwhile information to the commission in terms of fire code applicability as it relates to this. I do have his resume, if I could turn that in. Mr. Versteeg.
Is this a new witness?
It is his rebuttal witness, yes. But his comments will be in rebuttal to the questions that came up during the course of the hearing with regard to the applicability of which sections of the fire code, etc.
Good evening, Mr. Chairman, members of the panel. I'll try and be brief. What I intend to do tonight is provide some objectivity to some of the subjective comments that were made about the Connecticut Fire Prevention Code that the fire marshal used to determine adequacy of the site plan. The Connecticut Fire Prevention Code is an administrative regulation of the state of Connecticut. It's adopted pursuant to 29-291 of the Connecticut General Statutes by the Commissioner of Public Safety as well as the Codes and Standards Committee. The adoption of that document utilizes the National Fire Protection Association Standard Number 1, which is the Fire Prevention Code, and then amends it for use in Connecticut through additions, deletions, and altered wording for use in Connecticut. That document is the authority for interpretation of the state fire marshal. The local fire marshal, Fairfield Fire Marshal, can make the initial determination as to compliance by the strict verbiage of the code. If there's any question as to its proper application, there can be no alterations of that document. It must then go to the state fire marshal. And then it's subject to an appeal by Codes and Standards Committee. So, the issue has come up regarding the 20-foot road width, and there's been all kinds of discussion about that. I will tell you that the technical committee at NFPA 1, the NFPA technical committee members, as well as the NFPA staff, the reason for the 20-foot road width is that it facilitates two-way traffic. It also will facilitate one fire truck to pass another fire truck that has stopped either to connect with a hydrant or for whatever reason. So it's not that this is a very narrow road. The committee determined that 20 foot is significantly adequate for two-way vehicle traffic, as well as for one fire truck to pass another fire truck. The concern has been, and there was testimony the other night, that the Fire Prevention Code in Connecticut allows the authority having jurisdiction, keeping in mind that would be the state fire marshal, to increase the width beyond the 20 foot. And there was some discussion tonight about based on local fire trucks. That's not really quite true. If you read the code, it says that the authority having jurisdiction can increase the width of the road and or the height of the road where the 20-foot width or the specified height, the 13 feet 6 inches, is not adequate. Now, the reason that wording is in the code is not for everyday fire trucks. They all come as a standard width, maximum, because you can only have a truck a certain width for U.S. roads. Otherwise, it becomes an over width truck. This requirement has been put in the code for Bradley Airfield, Kennedy Airport, where you have fire trucks that typically are not driven on roads like aircraft rescue vehicles. They are much wider, they are much taller, they are much longer because they carry much more water, much more foam, because at the middle of an airport, there are no fire hydrants. So they have to be self-contained. So the reason that this requirement is in there that says, yes, you can go above if you have a need for it, is specifically for those aircraft fire trucks. So at Bradley, enforcing the Connecticut Fire Prevention Code, they can go in and say, we want our roadways to be 25 or 30 because we have this vehicle that needs to go down this lane. That's not for the everyday fire truck. The other discussion that was brought up, and there's been a number of references to NFPA Standard 1141, and it was also brought up by Attorney Green in this OSHA document tonight, Fire Service Features of Building and Fire Protection Systems. Now, this document references NFPA 1141 7 times. NFPA 1141 is also listed in the Connecticut Fire Prevention Code, but it's prefaced with the requirement that to the extent called for, you use NFPA 1141. The only place in the Connecticut Fire Prevention Code that even mentions 1141 is in a non-mandatory explanatory annex note, and then for calculating water supplies. It has got nothing to do with fire department road widths. Now, although it does contain fire department road widths and differing dimensions, the NFPA Technical Committee decided that the information within that document was not relevant and therefore did not put it into NFPA 1. When Connecticut adopted NFPA 1 and amended it for use in Connecticut, the State Fire Marshal's Office, the local Connecticut Fire Marshals Association, the State Codes and Standards Committee, no fire chief, no fire department, no public member at any public hearing or legislative hearing ever questioned the 20-foot road width or the use of 1141 or its lack thereof. So the Connecticut Fire Prevention Code of a 20-foot road width stands as the administrative regulation in the state of Connecticut. With regards to, there was testimony about backing up a fire truck. I will just reinforce that all vehicles over a certain size, including fire trucks, and you've probably heard it, when they put it in reverse, there's an electronic beeping or there's a bell sound, and that's to do what? That's to alert people behind the vehicle that you should look out, something's backing up. All fire trucks have that, and it is also standard procedure for when a fire truck backs up, because there's that huge blind spot behind the truck because the operator utilizes the mirrors, that a firefighter stands on the left side and on the right side and directs the operator of the fire truck backwards by motioning his hands, indicating that there's nothing behind him and it's safe. And we do this every time we back a fire truck into the firehouse. So backing a fire truck is very common, very common. In closing, Architect Hennessy described all the fire prevention systems within the building. What I would add is the fact that the concern has always been, you put these systems in the building. How do I know a year from now you're not going to turn them off? And that's always a concern. The Fire Prevention Code, the Building Code in Connecticut, as well as the Connecticut Fire Safety Code, prohibit those systems from being turned off. requires that these systems electronically monitored through the fire department. So just as if when you pull the red pull station next to the exit, you get an alarm, just as when a smoke detector activates, or just when a sprinkler activates, you get an alarm of occurrence, meaning it's an emergency. All of the switches and valves for all of the fire department sprinkler systems, that when you close the valve, it sends a signal to ADT or Sonatrol or whoever is monitoring it that someone has turned off the water. They then call the fire department because there's a trouble signal or a supervisory signal being reported. So these systems can't be turned off without notifying anybody, without intentionally notifying anybody. And whenever the system is taken offline, sometimes they're turned off for maintenance purposes, sometimes they're turned off because somebody was playing hockey in one of the apartments and they knocked a sprinkler off, like is common at a university, and you turn the system off. The minute you do that, the fire department automatically knows about it because you've turned the valve, and if you're planning on taking the system off, you must notify the fire department. And the fire department has an operational plan for what they do when that system is turned off. So these systems are always required to be maintained in fully operating condition by licensed individuals in the state of Connecticut. And there's severe penalties if you fail to do so. I hope that's cleared up some of the issues. If you have any questions, feel free.
Commissioner Barrett?
I have two questions. Mr. Versteeg, you have a question too, Mr. Pell? I was just reading because the applicant submitted some documents to us, so we're learning more about NFP 1 and NFP 1141, is it? I just want to clarify a couple points. The NFPA 1 document, when it talks about road width, it says that those shall have an unobstructed width of not less than 20 feet.
Correct.
It says not less than 20 feet, so that's the absolute minimum that's recommended here.
That's mandated.
That's
mandated.
Correct. I'm sorry, mandated is the right word, no less than. And then we were also given copies of the 2012 and 2008 NFPA 1141.
Yes.
That's in the record, and that has a different description of roadways.
Yes, it does.
It says, roadways shall have a minimum clear width of 12 feet, 3.7 meters for each lane of travel, excluding shoulders and parking.
Right.
I just, that says something different, whether that's the controlling thing or not. That talks about a lane of road, so it wants a 12-foot lane. So obviously, if you have a 2-lane road, it's going to want it to be 24 feet. I mean, aren't some of the practical differences, this also deals with one-way access, one-way exit, if there were 2 different access points and it wasn't 2-way traffic there, it wouldn't necessarily have to be 20 feet wide, it could be 15 feet wide and comply.
Yeah. Well, I will tell you that NFPA 1141 is an antiquated document in that it has an origin much earlier than NFPA 1 does.
Okay.
And it does have a distinction between fire lanes, fire access roads, roadways, in varying dimensions for each of those, whether they're publicly owned or privately owned. When the NFPA 1 committee saw fit to incorporate the requirements for NFPA 1 for fire department access, as well as the building code, the committee I chair for the building code that deals with fire department access, we looked at all of that information and said, you know what? The data is there for a 20-foot road to provide for 2-way traffic, as well as for one fire truck to pull around another fire truck, whether it's stopped at a hydrant and connecting to a hose, or it is broken down, or the driver doesn't know where he was going and the second fire truck will lead the way. There's sufficient road width for that. So if we just say at least 20 feet, that satisfies all the requirements we need, and there's really no distinction to make all these different references, because it was confusing the heck out of people. What was a fire lane versus a fire road versus, so they just ignored it. And that's why NFPA 1 has not adopted it, and that's why Connecticut has not adopted it.
Commissioner Jacobs?
I just have a question. What if there's more than one vehicle that needs to get in and out? I mean, an ambulance or 2 fire trucks or a car or whatever. I mean, if the fire truck is there blocking a 20-foot road, it's 19 feet. I mean, how does the ambulance get out quickly?
Well, typically, the fire truck is not going to block the entire width of the road. The 20-foot allows for a fire truck to stop and an ambulance to go by, or another fire truck to drive back the other way. The road is sufficiently wide for that to occur. Where you get into blockages is once the fire trucks are committed and the hoses start to come off and be charged with water, We only do that when there's an actual fire in the building. So although a number of fire trucks may go to the building, we don't lay down the outriggers, we don't start pulling hose off, we don't start charging lines, we don't commit those until somebody goes in and finds out what's the actual problem. And then we may use them all if the fire is severe. We may turn everybody around if it's a false alarm. We may just keep one truck there and return the others to service. So those are tactical decisions made by the incident commander, but it's not, we all get there and we jam up and we're ineffective for the rest of the day.
Commissioner Kennelly.
Thanks. Mr. Versteeg, a couple things. Just want to clear up since we received your CV as part of the record. You were the commanding officer for technical services for the Connecticut State Fire Marshal's Office until December 1996?
Correct.
Since leaving that post, 17 years, 7 months, you have served as the principal for Versteeg Associates?
Correct.
And my understanding is, taking a look at your LinkedIn, you've been a consultant as far away as Abu Dhabi, is that correct?
Abu Dhabi, yes.
Abu Dhabi. Well, thank you for correcting me. My question is in those nearly 18 years of experience, you haven't had an enforcement role in that nearly 20 years. Your role has been to testify or work on behalf of clients. That would be correct, right?
My role in those 17 years has been to apply the code. We assist designers in the development of projects.
We work on behalf of...
for towns.
Right.
We do some legal work, sometimes civil cases, sometimes criminal cases.
Could I ask you, in the 17 years and 7 months of your experience, could you estimate how often you are working on behalf of a client who is seeking to create a project in which they need support to say that the minimal standard, for example, is appropriate, versus when you would be testifying or speaking on behalf of local groups or other organizations that might be concerned? How often would you say you're working for developers, folks like that, 80-20, 50-50, 90-10? Well, how would that work, saying that the larger or less, or the first denominator being, an organization of some kind?
Probably once a year.
Once a year?
Yeah.
One organization per year, one client per year?
One incident, one of these, what we're doing now per year.
And what's the rest of the practice then?
Plan reviews, third party from municipalities, teaching internationally, building code, fire prevention code, life safety code.
Were you a commanding officer of any fire department? Were you like a chief, a captain? Did you serve as a lieutenant,
I was
a
a captain in
battalion?
the volunteers in New York State before joining the...
Where in New York State were you a captain of volunteers?
Hillsdale, New York.
How large a population in Hillsdale?
Very small.
How much, would you guess? You were the captain of volunteers?
About 4,000.
How much?
About 4,000.
So 4,000 citizens?
Yeah.
Okay, thank you.
Mr. Coleman?
I had a question. Our fire chief, or our former fire marshal, showed us yesterday the width of a truck with stabilizers extended. Under what circumstance, and that brought it, my recollection was out to 19 feet, under what circumstances would one extend stabilizers? And would this likely to happen during a fire incident?
Yeah, the stabilizers are on vehicles that we would call like a ladder truck. The trucks that you see that have the ladder that raises automatically, just like a construction truck. When you raise that ladder and start to turn it, it tips the truck. So these outriggers come down and sort of lift the tires off the ground so that the weight of the ladder is not, moving around based on the softness of the tires. It's actual steel to solid ground. So those outriggers come down to stabilize the vehicle. That only occurs when we're going to commit the ladder and raise it. So typically a ladder truck will come to the scene, wait, we get ready, and do what you need me or not. Most times in a sprinkler building, what I may need is a ladder off the back. We pull a ladder off and we hand carry it in. Very rarely do we have to raise the ladder. If we do, then we have a fire and we're committed.
Thank you.
Anyone else? No? Thank you.
Thank you.
One quick question. There was a lot of questions last evening about one versus two access points. Can you just very briefly address any comments you think are relevant to that testimony?
Yeah, the standard, NFPA 1, as well as the building code, and as well as 1141, require at least one access into the site. And then it says that if that one access, where there are conditions that may block it, you should consider having two. Now, on the general surface, you would start to think about what if a car stalled, what if a tree fell down. What was in the committee's mind when they discussed this, and you look at the substantiation, just like you would as a lawyer look at the legislative history of a statute to find out what they actually mean, they're talking about catastrophic events. They're talking about mudslides, avalanches, that when it occurs, that access is really closed. They talk about railroad tracks. Now for us, railroad tracks, I mean, the train passes very quickly, but if you're out in Colorado or Montana or Nebraska, I mean, that train could be 15 miles long because it's on flat. That's what they're considering. So in this case, you don't get those catastrophic events, so we're concerned only with the one.
One last question. I just want to make sure I'm clear. This matter of 13 feet 6 inches vertical access, that doesn't relate to completely under the building, does it? What does that refer to, the 13 feet 6 inches?
The 13 feet 6 inches refers to that portion of the fire department access road that would restrict an overhang, like a bridge or a overhead steam pipe or low-hanging cables or tree limbs that would prevent the fire truck from getting underneath that and actually accessing the building.
Thank you. Anything further?
I don't have anything further. Oh.
Thank you, sir.
Thank you.
Mr. Chairman, under the circumstances, is there an opportunity for cross-examination of this witness?
You object? He's a new witness you brought in for rebuttal.
That's quite all right. I just have a few brief questions.
Certainly.
I'm Joel Green. I represent the Lower Bronson Neighborhood Association. To what degree have you had an opportunity to review the site plan for this development and the proposed structure?
I looked at it this morning.
And was this the first time you'd seen it?
Yes.
And did you have an opportunity to calculate the length of the driveway or the road and driveway from Bronson Road to the structure?
I did.
And do you know how long that is?
It's over the 150 feet. It's a couple hundred feet.
200 feet?
Maybe, yeah.
Okay. And are you suggesting that there's any standard with respect to what you've characterized as a 200-foot-long driveway in terms of allowing a turnaround for emergency vehicles on the site?
Yeah, the standard says that requires that if it's a dead-end roadway and it's in excess of 150 feet, then you need to provide a mechanism to turn the vehicles around. They don't want them backing out 150 feet.
And there was no such mechanism on this site, is there?
Well, the way the road forked as you approach the building, and I didn't scale it, I didn't have a scale drawing and I didn't have the vehicle templates, but there was almost what they call a turkey leg, where the road goes up in Ys and you can drive up into one and back up into the other and reverse your turn versus a cul-de-sac. The roadway going into the garage and the roadway going around to the other side provided sort of a turkey leg. Now, I didn't evaluate it that closely as to whether the vehicle could actually make that turn or not.
So you don't know whether there's adequate turnarounds on the site or not?
I didn't make that determination, no.
And similarly, if the driveway were 600 or 700 feet in total length, would that change your opinion at all?
No, if it's over the 150. The 150 is the maximum that we determine you can back out of.
Okay. And just give me a brief moment, Mr. Chairman. In fact, you had referenced the NFPA 1141 in your original submission to the commission, didn't you?
In my original submission.
In other words, you had authored a document to the commission dated July 9th that sent it to Richard Friedman.
May I see it?
Sure.
Yeah, I referenced the NFPA 1, Connecticut Fire, 2010 Connecticut Fire Prevention Code. No mention to 1141.
Well, as I understand it, there was a document attached. Did you have anything to do with, and I'm showing you some documents that are attached to this submission, including specifically a portion of NFPA 1141, the 2008 edition, and at page 11 of the submission dated July 9th, and similarly NFPA 1141 at page 17. You were not part of submitting that document?
No, I was not.
Oh, that's right. Did you study the proposed fire lanes or access to the structure in terms of the location of parking on the site? Were you asked to review that?
I was asked to look at fire department vehicle access.
And did you study them in relation to the parking spaces on the site?
Yes.
And are you satisfied that having parking spaces between the driveway and the structure is desirable or acceptable?
It's not prohibited.
It's not prohibited. Is it desirable?
I don't think in any way interferes with the access to the fire truck, if that's what you're asking.
And are you aware of the inventory of equipment that Fairfield uses in responding to fires?
Its specific inventory? No.
Yes. And are you aware of the location of the specific responders in terms of the location of fire departments relative to the site?
No.
And did you review the geometry of the site in terms of the traffic on Bronson Road, the width of access road, or the geometry of the intersection between the proposed road and Bronson Road?
No, I didn't. And the reason I didn't is that emergency vehicles have lights and siren, and by law, when they activate them, you have to pull over. So you tend to get clearance.
And did you have an opportunity to review the traffic reports by any of the consultants in terms of the stacking of traffic and queuing of traffic on the site?
I did not.
And are you aware, and have you had an opportunity to review sites that are proximate to facilities such as train tracks with overhead electric wires and train tracks? Have you had an opportunity to review those sorts of sites in your experience?
No, not train tracks, no.
And so you didn't review this site in terms of the proximity of the building to the Metro North property?
No.
And did you have an opportunity to review this site in terms of other properties that would access the site, such as the Kovacs property or the Metro North property easement, in terms of what I'll call the geometry or the setup of that and its impact on the access? Were you asked to review that?
No.
In fact, have you had any opportunity to study the potential traffic volumes on the site by virtue of a 95-unit apartment building of this nature?
No.
I have no further questions.
Thank you. Mr. Fallon?
Thank you.
Thank you.
If the commission can bear with me, I think I can promptly summarize and, if not get us out here by exactly 11 o'clock, certainly within 10 or 15 minutes of that time. Let me briefly cover the issues that I think have been brought up during the course of this hearing. Again, I thank the Commission for their time. The driveway width and the NFPA standards, you've heard the testimony tonight of Mr. Versteeg just a moment ago. You have in your package of material that we delivered earlier this week a memo from Branson Willis. It's page number 13 on your material. Basically, where our position with regard to the whole matter of the driveway width is that the 20 feet proposed driveway width is well within Connecticut, both CONDOT and fire safety standards. And frankly, the width that Ms. Pooley suggests in her memo of 30 feet would be the absolute maximum allowable to access onto the state highway under those same guidelines. So we believe strongly that the record demonstrates that the driveway width as proposed is appropriate. I would also point out, you have in your original application package the police department comments at page 31, the fire marshal comments, which are still of record, page 35, and are uncontroverted. I think also the Fairchild site plan, which was introduced by both us and Mr. Green, there you have a situation when you have a chance to study that. There's a 400-foot long driveway. It's longer if you treat the dead end running all the way from Kings Highway. And again, there's no facility there for backing up either. So we think this is a very, very similar situation. Before I go on, let me ask Ms. Francis, we are adding 74 deciduous trees, shrubs. There'll be 20...
Mr. Fallon, I'm sorry to interrupt. You just said 400-foot driveway on Fairchild?
Correct.
The driveway from the street to the building is 400 feet?
It's my understanding, yes. You can calculate it, but
About 10.
the length of the parking area is what I'm
The
referring to.
length of the parking?
Correct?
Okay, no, it is what it is, but...
It is what it is.
I just wanted to be clear as to what you were referencing as 400 feet.
It's the length of the driveway, of the parking area.
Okay?
And
The site plan is in the record, so...
It does, yeah, it's there. It does dead end. The status of the road, there's been a good deal of testimony on, and you have a memorandum, again, from Mr. Brantz's office. It's page 8 of your submission. Basically, we feel very, very strongly that, first of all, this is a driveway. Ms. Pooley repeatedly describes it as such. The town doesn't plow it. The driveway is located on town land, so are the driveway leading to the school, and now through this parking lot. That doesn't make it a public highway. Even if you assume, however, that Mr. Green's position is correct, and the town consent, if you will, is required to alter that roadway, not Mr. Kovacs, but the town's. The improvement that we're making here and that are in the site plan we've submitted at our expense were made at the request of the town staff. The hydrodynamic separator, the access to the Kovacs property, the curvature so fire trucks can gain access, all these things came from comments and requests from the town. We might disagree with Ms. Pooley about making the road wider, but no one felt that that town road should be left as is. You can't, in this particular situation, basically indicate to us that, hey, it's a town road, you can't improve it without our permission. Here we've offered to improve the town road, and now say, well, we don't want you to improve the road, and now we're going to deny the application because the road, in our mind, is insufficient to do what you want to do with it. And if you read the entire memo, I disagree with Mr. Green. Clearly, the cases that are cited, Butternut Farms and the Columbia LLC case, do stand for that proposition. And if you want to say this is a town road, then you can't say that despite our willingness to improve it, it's a basis to deny the application. If you feel the road needs improvement beyond what we are suggesting is fair and safe and adequate, then the town can address that. There were concerns about Mr. Kovacs. Again, the plan that we made for Mr. Kovacs was at the direct request of Ms. Pooley. We were basically giving him an easement to allow better access to his property and, in fact, to give him more yard area. As we pointed out before, if he doesn't want it, if he wants the status quo to be maintained, then that's fine. We can and will do that. Pedestrian access has been discussed a great deal as part of this application. We don't feel that our particular proposal involving the mix of one-bedrooms and studios is likely to produce enough children based upon our rental experience to require a school stop at the driveway. Irregardless of this, if you look across the street, there's a 24-unit condo. If you check the assessor's records, 16 of those are 2 bedrooms, 8 of them are 3 bedrooms. So they have a total of 56 bedrooms. They also, directly across the street from us, number one, have no internal sidewalks and no means of pedestrian movement on the street, except by walking down the driveway, just as the case here. There were concerns raised about the condition of the sidewalks that do exist on Bronson Road. Again, analogous to the situation with the roads. These are town sidewalks. If the town feels that they need to be improved, then they can use some of their grant money to fix them. But again, similar to the Holding and Buttermilk Farms, you cannot say that public sidewalks are needed for public safety when it's the duty of the town to build them, if that is the town's desire, and deny the application of our application on that basis. Traffic, you have all of the data from everyone. The simple fact of the matter is we used ITE numbers that had 7 data points, as Mr. Ha reemphasized today. In this particular case, one of the points Mr. Spear made was that he felt, although we would not agree, that a bypass lane is needed to avoid problems with left-hand turn incidents. If that's the case, then again, that is something the town can do. We don't think it's necessary. We don't think the traffic data justifies it or warrants it. But again, it's not a basis to deny this 8-30G application if there's a concern about the adequacy of Bronson Road, which is a public road. We did confer with the DOT in New Haven about a year and a half ago. They had not then, and they do not now, have any objections to our proposal, and we did review it with them carefully because of the proximity of the entrance ramp. Parking. Basically, first of all, this is the same ratio of parking that you approved at Fairchild, 1.2. I think Mr. Wa's analysis is comprehensive. I think he used the proper ITE methodology, and I would submit to you that his actual parking analysis is also very good. With all due respect to Mr. Green and Mr. Blumenthal, and I'm not going to go over this whole thing at this late hour, I would point out to you that the Fairchild project, which is approved, has a bus stop approximately 800 feet from it. It's hard to find, but it is there. Our site is 800 feet from a very well noted bus stop as well. Similarly, Fairchild, as pointed out, is 1.3 miles from the train station. We're 0.9 miles from the train station. So in the final analysis, we believe very strongly that the parking ratio that you approved for Fairchild is appropriate here and should be approved, and that all the other questions with regard to parking and on-street and off-street are speculative. We're doing nothing more with regard to this aspect of the matter than simply applying the same standard that was stipulated to on Fairchild. Contamination on the site. We did a site evaluation, both a phase 1 and phase 2, before we ever applied for an inland wetlands permit. That wasn't required by the DEP or state law, but as I think it was Attorney Braun who pointed out, when someone buys a piece of property, they buy whatever contamination is there, and so you want to know what's going on. Site remediation is governed by state law and regulation, and the DEP is the agency charged with supervising site remediation. We didn't originally submit the ESA material to the Conservation Commission, since we weren't doing any disturbance in the wetlands area. When Ms. Jacobson asked for the phase 1 and phase 2, we did them, and we submitted them to her. When she asked for, and the intervener's LEP asked for more testing, we performed it and provided the results. Ms. Jacobson and the intervener's LLP, as Ms. Braun testified, did want more tests in different areas. Our LEP considered it to be unnecessary. The intervener's LEP testified before the Conservation Commission that our LEP had done a competent and proper site evaluation, but that he would have done it differently. Honest professionals can differ. As clarified by the July 9th letter from Ms. Kallenberg, this site is under no consent orders or remediations orders from the DEP. As I well know, the contamination that may be in the Mill River must be cleaned up by others, but not this property owner or applicant. The bottom line here is that state law governs the level of site remediation that's required, not local zoning, and there's no evidence that the site contaminated in any way that is different from other sites in the area. And if there were contaminants, then the mandated work by the state, by the way, to remediate that would be to cap those contaminants with paving or a building anyway, which is precisely what we're doing. You have reports here on this topic that Ms. Braun introduced. I didn't object to them, nor do I, but I would point out for the record that those reports were produced by experts who were not brought here for testimony and an opportunity for cross-examination. The last thing on that particular point that I wanted to talk about is the Epiliti case, which Ms. Braun submitted. I know you have in your diligence read it or shortly will do so. The simple fact of the matter is it's a much different situation. And what it really involved basically was, in this case, that commission asked the plaintiffs to provide a groundwater mounding analysis. The plaintiff originally agreed to do that, and then subsequently the plaintiff reversed its decision and refused to provide the groundwater mounding analysis that they had previously agreed to do. And the commission at that time, being up against the statutory clock, which you can identify with, decided to close the public hearing without the groundwater mounding analysis, and then they approved the application with a condition of approval, including groundwater mounding analysis. And the recalcitrant applicant took an appeal on the basis of that commission. And based upon that record, the court found that in fact it was an appropriate condition to offer because, as the court pointed out, the record contains evidence as to a quantifiable probability that a specific harm will result if the application is granted. Mere concerns alone do not amount to sufficient evidence to support the denial of an affordable housing application. So it's a completely different case. And it doesn't stand for the proposition that one can speculatively impose here testing requirements that the Conservation Commission, after 2 nights of public hearing, didn't see fit to do. Also, I point out that the whole question of the removal of debris, which Mr. Green talked about tonight, that's a condition of the wetlands permit, which is part of your record. We have to do that. We will do that. There's no question about that. So I think ultimately, our position with regard to that aspect of the matter is that we've more than adequately addressed the record in terms of contamination on the site. CAM, very briefly, that was touched on tonight in the context of the debris removal. That's a condition of approval, and we're going to do that. You also have in your record Michael Klein's letter, which was submitted with the package of our material earlier this week. I think he, and along with Ms. Kallenberg's subsequent letter, clearly clarifies what the statutory requirements are and are not here. And although, as Mr. Klein points out, and we would confirm, there's nothing here based upon the statutory criteria that he cites that would warrant or require the imposition of coastal access amenities, because there is not going to be any preclusion of existing or future water-dependent uses. Nonetheless, for this record, the applicant has agreed that appropriate public access provisions and a gazebo are something that we would certainly be willing to address and abide by. But I think the ultimate document of evidence or record here is Ms. Kallenberg's revised letter. The WPCA, I submitted a memo, I think it's at page 4 of your material. It very clearly, relative to the holding of the CBM capital appreciation case is directly on point here. You have it. I know you will read it or have. The simple fact of the matter is CBM stands for the proposition that the proper way to address a matter of the WPCA in the context of an 8-30G application is to make the obtaining of a WPCA approval allowing the sewer connection to be a condition of approval. And we certainly agree with that. To re-echo what I said to the chairman before, we agree that the sanitary sewer availability is a public health and safety issue. Therefore, it should be a condition of approval. And if we don't get the WPCA approval, we don't have a project. So there's no dispute about that. But I think CBM clearly establishes the proper basis for that being dealt with, as with other factors, as we talked about earlier, in the context of an 8-30G as a condition of approval. Second to last, I just wanted to address, there was a colloquy the first night between myself and Mr. Kennelly. I had cited interfaith housing of West Hartford versus West Hartford as a proper standard for aspects of an 8-30G application. He was on his iPad, and he referenced to me quickly reading from Christian Activities Council versus Glastonbury, and I said, yep, well, that wasn't the case I cited, and that was an important misstep by me that I want to make sure the record's clear on, because when you read the material that we've submitted, the memo that we've submitted on this point, Christian Activities Council versus Glastonbury and the standard that Mr. Kennelly understandably cited has been overruled because of that holding, and indeed there was a public act by the legislature which clearly changed the standard for what the standard of judicial review of these decisions are. And we gave you a copy in our material of the Quarry Knowles versus Greenwich decision, which very clearly enunciates that standard, and I commend that case to you, because when you see it, you'll see that we're not dealing in 2014 with a sufficiency of the evidence standard, as was the case when Christian Activities came down. It's now a standard that really is going to require a de novo review of your activities relative to determination that there was a public health and safety issue or issues that outweighed the need for affordable housing in this community, and that those concerns of public safety could not be addressed by appropriate conditions of approval. So that's the points. And I guess I end where I began. In your original material, page 4, and I'm not going to read them to you again, there is almost 2.5 decades of comment and statements, not by me, not by anybody else, but by our town, about the tremendous need for affordable housing in this community. 88, 2013, and all years in between. I would submit to you, gentlemen and ladies, that the time to act is now. These applications aren't easy. The legislature doesn't make them easy for us or for you. But the simple fact of the matter is, we have said repeatedly that we need to address affordable housing in this community. This is a perfect location for affordable housing. You have within your authority under 8-30G the right to review this application and condition it in a manner that you feel is justified by legitimate public health and safety concerns, and that's why we provided you, we didn't intend to upset the apple cart, with conditions of approval that we thought might be responsive to your concerns that we would not object to. But at the end of the day, the one thing in all of these 16 hours of public hearing that we really haven't dwelled on is affordable housing and the statistics that are contained in our application. 2.6% of our housing stock is affordable. Dead last of 22 municipalities taking block grant funds. We need to address that. This application, which is quite similar to the application and was designed in accordance with the standards of the application that you approved by stipulation in court, the Fairchild application, these are the types of projects that we need to address if we're going to put our money where our mouth is in terms of affordable housing. And at the end of the day, that's what we asked you to do. We asked you to apply the statute, utilize the authority you have under the statute, but examine the evidence of record and be clearly aware that the standard is a strong one because of the state's belief that affordable housing is an absolute public policy priority. And that therefore, if you were to deny this application, you need to have demonstrative evidence in here that there was a public health and safety issue or concerns that outweighs that need for affordable housing, and that you could not have addressed through a condition of approval, similar to the ones we offered to you tonight, without avoiding the whole matter of finally addressing affordable housing in the town. Most sincerely, I thank you. I know this has been a difficult application for all of us. Your diligence and fairness and courtesy is appreciated, and we leave it to the record with the hope that you will approve this application so that we can finally say, again, as I think we probably started to say with Fairchild, we do mean what we say to the state, to the federal government. We do mean what we say in Fairfield about affordable housing, and we're acting in accordance with that belief. Thank you very much.
Mr. Fallon?
Yes, ma'am.
Did you answer my question?
I'm sorry, I started to, I didn't. We have 74 species of deciduous trees and bushes that will be planted under the landscaping plan you have.
Yes,
and we have 26-inch or less diameter trees that will be taken down.
And how many, okay, and that's all that are there is 26?
20 down of 6-inch or less caliber.
Okay.
That's the only tree removal, and 74 new species of trees planted.
Okay, thank you.
Thank you, thank you. No, thank you very much.
The hearing is closed.